May I mention one case? The case number WPC 1709. This is listed for tomorrow, and the respondent number 6 was supposed to file a supplementary affidavit by yesterday. Affidavit was done. State was served the copy, but petitioner could not be given a copy. So
file it here. You give it to the petitioner.
Today we will do.
Yes, do it.
So allow me to, because
you don't need to say anything. These are absolute formalities. We don't bother about it.
From the supplementary
yes, madam.
Mentioned against the award for regularization after 14 May 2020, it is not listed till date. Out of list here.
From the supplementary list under heading for admission, item 2, WPC 803 of 2020.
Petitioner? Yes.
Under date 9 September 2024, may I kindly disseminate it?
Yes.
Yes. No affidavit in this consonance has been filed till tomorrow.
Did you file the required affidavit?
We have filed an application on it. We have filed our reply recently on 25/11/24 litigation.
25/11. On 28th October, it was said that the reply to the supplementary affidavit.
Yes, that we have filed.
The supplementary affidavit.
Reply to the supplementary affidavit.
Yes, the matter was adjourned.
And this is on, we have filed on 25/11/24.
Yes, on 28/11 it was adjourned on the ground that you would seek, you will file a reply to that.
My lord, that has been filed.
Your reply has been filed.
My lord.
So why are you referring to order dated 9th of September 2024?
My lord, the reply which was filed on earlier occasion, my lord, the suspect had not been. The issue, if my lord will kindly consider, thereafter when this relevance of this order will come, my lord.
You did the order dated 9th September 24.
9th September.
Yes.
My lord.
Planning.
It has been submitted by legal counsel for the petitioner that the notification relied upon the respondent is not applicable in the facts of present case, as the number of labor is below 10 and the work has been completed within 30 days, and as such the notification is not applicable in present case.
What
My
is
lord,
the cause of action to file this writ petition?
my lord, Annexure 8, page number 113. This is referred to the petitioner श्री उदय सिंह. आपके पत्रांक संख्या सच एंड सच जो वर्क ऑर्डर नंबर सच एंड सच डेटेड 3/11/18 एवं 18/1/2019 के लेबर पेमेंट सर्टिफिकेट से संबंधित है के संदर्भ में आपको सूचित करना है कि इस संदर्भ में आपको पत्रांक संख्या सच एंड सच के माध्यम से जानकारी उपलब्ध कराई जा चुकी है कि आपके वर्क ऑर्डर में स्पष्ट रूप से दर्ज है कि ठेकेदार CCL के क्लिप सिस्टम के अनुसार ही श्रम मजदूरी का भुगतान करेगा. अतः उपरोक्त मामलों में बिना क्लिप सिस्टम के माध्यम से लेबर पेमेंट किए बिना प्रावधान लेबर पेमेंट सर्टिफिकेट जारी करने में असमर्थ. प्रबंधन लेबर पेमेंट सर्टिफिकेट जारी करने में असमर्थ है. अतः उक्त पत्र के साथ आपके द्वारा प्रेषित सभी मूल प्रपत्र को वापस किया जा रहा है तथा साथ ही सलाह दी जा रही है कि लेबर पेमेंट सर्टिफिकेट जारी किए जाने हेतु क्लिप के द्वारा लेबर पेमेंट डिटेल तथा कार्य आदेश की छायाप्रति की प्रति ही हस्ताक्षरी के कार्यालय में भेजे ताकि आपके मामले का निष्पादन किया जा सके. My lord, one tender was issued for erection of 11 kV line to main substation Religara. That work was allotted to the petitioner. The petitioner has completed the work within 1 month. The two relevant clauses around which.
No, I just want to know that basically your payment will be dependent upon the labor payment certificate.
My
Now, whether how many workmen are involved in this case, is it undisputed?
Yes, it is undisputed.
From where do you say? You say that it was less than 10%. From where do you say and from where do we get that? It
Because
is basically for recovery of money, isn't it?
yes, ma'am.
Well,
I have
yes.
completed the work, my lord.
Must have.
Only one clause, my lord, around
No,
which
no, we are not here to interpret the agreements. It is either you say that you just now said that the number of workmen was less than 10. From where do we get that it is an admitted fact? Firstly, this fact is required to be an admitted fact. And secondly, the clauses of the agreement is required.
Yes.
Where have you stated in your petition that it was less than 10%?
my lord. In fact, my lord, Annexure 2 itself.
Annexure से नहीं चलता with petition number 10. Respondents are not are supposed to answer to your annexures. They are supposed to answer to your pleadings. So show it from the petition. You file a suit for recovery of money. We are not here to decide your suit.
Yes. It is in the supplementary affidavit filed on behalf of the petitioner.
Which is
Para 8, my lord. Supplementary affidavit filed on 9 September 2024.
9 September 2020.
4.
Yes.
Para 8, my lord, on page number 3, that it is very relevant to mention that during pendency of respondent number issued labor payment certificate of both of the ways, stating therein that the organization is not covered in the portal since petitioner had not engaged more than 4 and 2 laborers in both the works. So, if once my lord will kindly come to the clause, my lord, that will clarify the entire issue. Entire thing revolves against, my lord, that. It is on page number 89, my lord, their work order itself.
Just a moment. Where is your reply?
Ladyship, with respect to the certificate that the learned petitioner is, the advocate is relying upon, we have stated in para 7 of our reply to the supplementary affidavit. And before going to that, Ladyship, may kindly peruse that certificate at page number 7 of the supplementary affidavit. There is no date, nothing has been mentioned in that annexure at page 7.
Is it not your document?
We have written a letter to that person because he has been transferred to some other place of the subsidiary leadership. That whether this has been issued to him or not. And
It must be there in your record.
no, it is not there. That we have mentioned in para 7. That may kindly be seen. Para 7 at page 4 of my reply.
Yes.
That it is stated that the petitioner during the pendency of the writ application has filed a supplementary affidavit stating that respondent number 7 had during pendency of the writ application issued a letter bearing such and such dated 24/3/2019 certifying that payment has been made as per the minimum wages. When such supplementary affidavit was filed, the answering respondents were directed to seek instructions on the same. In course of the inspection, it was found that the final bill was submitted by the project engineer E&M with respect to 2 work orders along with the following enclosures. That enclosures are important, Ladyship. Bill amount copy, tax invoice, performed B, store material statement, completion certificate, photocopy of the letter is annexed. Next para, that it is stated after filing of the supplementary affidavit for the purpose of preparing the reply when the
It
file
requires
was
proper adjudication. It's not an admitted fact.
we have not admitted the document because even if we peruse the document of the final submission of the bill in the enclosure, it has not mentioned that payment of labor certificate. No date, nothing is there. The signature also, we have sent the letter for verification, but we are not admitting the document.
They are still in process of getting it confirmed.
No, it's okay. That confirmation will not do. There is a dispute, you go and file your suit for recovery of money. WPC number 803 of 2020. For the learned counsel for the parties, district petition has been filed for the following relief. The learned counsel for the petitioner has referred to order dated 9th of September 2024, which is quoted as under. The learned counsel for the petitioner, by reference to the aforesaid order, had submitted that the relevance of the number of workmen who had worked in the execution of the allotted work to the petitioner assumes importance inasmuch as the clip system is applicable only in the circumstances where the total number of workmen exceed 10. He submits that though no specific statement has been made in the writ petition with regard to the number of workmen employed, but a supplementary affidavit has been filed by the petitioner annexing therewith a copy of certificate annexing therewith a document and stating that during the pendency of the writ petition, the respondent number 7 within bracket personal manager issued a labor payment certificate of both the bills, stating that the organization not covered in CLIP portal, since petitioner is not engaging more than 4 and 2 laborers in both the work. The learned counsel submits that on the face of the said document, annexed with the supplementary affidavit, it stands admitted by the respondents that the number of workmen were only 4 and 2 in both the works, and therefore the clip system is not applicable, and therefore there was no requirement to produce the labor payment certificate in terms of the impugned letter dated 27/8/2019. He submits that the work has already been completed, and therefore a prayer has also been made seeking a direction upon the respondents to make immediate payment of the entire bill to the petitioner with interest. The learned counsel appearing on behalf of the respondents has opposed the prayer and has submitted that a supplementary counter affidavit has been filed in the present case, disputing the document annexed along with the supplementary affidavit. She has submitted that the said document does not even have any date of issuance. The learned counsel submits that essentially this writ petition has been filed for realization of certain dues arising out of a contract, and on account of disputed questions, this writ petition to the petitioner may be the relief as prayed for may not be granted. That's all. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that essentially the writ petition has been filed for realization of certain amount which the petitioner is said to have, which the petitioner claims to be payable arising out of contractual work performed by the petitioner. There is a serious dispute in connection with applicability of flip system in connection with the execution of the work, and disputes have been raised by the respondents. In view of the disputed questions involved in the present case, this court is not inclined to grant the relief as prayed for in this petition under Article 226 of the Constitution of India. However, dismissal of this case will not be an impediment for the petitioner to avail the remedy available to the petitioner for realization of the dues as permissible under law. This petition is accordingly dismissed.
Item 3, WPC 3662 of 2020.
Petitioner. Where is the petitioner? Have you seen the report?
Yes, Your
मिसेस रितु कुमार को बुलाइए. आप हैं इसमें? Are you there? I don't remember the name. मिसेस रितु कुमार का नाम फ्लैश करके इनको बुलाइए. We are just passing it over. Come at 1.
One.
Item 4, WPC 2336 of 2021 along with item 5.
Let's agree that it will be taken after lunch.
After lunch. कल ही तो आप बोले थे.
Lot people are asking us.
सीनियर के नाम पे ना टाइम पूछ के लिया करिए. एडजर्नमेंट कोई भी चीज. कोई बात नहीं. लंच पोस्ट लंच.
Under heading for hearing, item 6, WPC 548 of 2015.
Yes, petitioner. Where is the petitioner? You were saying something on the last day.
My leadership, actually, this order had been disposed of, my leadership, and then it was recalled. When it was disposed of, the client has taken a file from us, my leadership. In civil review, it had been recalled.
I think Mr. P.P. and Roy was appearing in this case at the time of recall. बुलाइए उन्हीं को बुलाइए. जिन्होंने रिकॉल कराया उन्हीं को बुलाइए. Mr. P.P. and Roy or
We did not appear in the review case also.
no, Pragati Prasad was appearing in the review petition.
Yes, my leadership.
And Mr. Kashish Tiwari was appearing for the writ petition. Kashish Tiwari is from the office of Mr. Indira. बुलाइए उन्हीं को बुलाइए. कशिश तिवारी का नाम फ्लैश करें. You were representing whom in the petition?
My lord, the respondents were the purchasers of the land. It was an SAR case, my leadership, and there was a dispute regarding the compensation and amount.
All the three petitioners have passed away. WPC number 548 of 2005. Nobody appears on behalf of the petitioners. It appears that this petition was disposed of by an order of this court dated 7/9/2018. Wherein it was not brought to the notice of this court that one of the private respondents of the petition, namely Sambhu Pandit, had expired during the pendency of the petition. The records reveal that a civil review number 11 of 2022 was filed on behalf of the legal heirs and successors of the deceased Sambhu Pandit, and in the civil review application and the order passed in the petition was recalled, and this petition was placed for fresh hearing. The order of the civil review application reveals that it was submitted by the civil review petitioner, but it was submitted by the counsel for the petitioners in the civil review that all the three petitioners have passed away, and in the civil review application the legal heirs and successors of the petitioners were made party and they were represented by a counsel in the civil review application. Now the case has been placed for fresh hearing, but no steps have been taken by the legal heirs and successors of the original petitioners who have already expired in the present case. In such circumstances, this petition is treated as abated, as all the petitioners have already expired.
From the daily list, under heading for final disposal, item 1, WPL 2947 of 2011 along with item 2.
12:30.
Item 3, WPL 3094 of 2012.
Yes, petitioner. Where is the petitioner? Where is the respondent? पास ऑर्डर करें मिस्टर सचिन कुमार का नाम फ्लैश करें.
Item 7, WPC 5436 of 2018.
Yes, petitioner. Yes. He was here right now. He was here right now.
Yes, yes, he was here and he was writing some other cases.
Call him then. Call him then.
Yes,
If
my
he
lord.
has to argue, call him. It's Passover. Come at 12:30.
Under heading for orders, item A, WPC 4180 of 2006.
Understand that the sole petitioner has died. We are trying to establish contact with the legal.
Sorry?
The sole petitioner has died.
So?
We are trying to establish contact with the legal.
You're not able to contact.
One last indulgence which I can
This matter is pending since 2006.
we
What are you doing?
have made a correspondence also, but
There is no response.
as of now,
If there is no response, we will say that you don't have any instructions. Whenever you get instructions, you come and file your petition for restoration. What can be done about
last
it?
indulgence will be given.
No, you see, in 2021, this case, it was recorded that the sole petitioner has expired. Why should we give you more time? They are not bothered about it. Why should you bother? Isn't it? 2020 also it was submitted that the sole
We
petition.
have also made a correspondence
No,
through letter.
that's why we'll say so. We'll say so. Don't worry.
2 weeks indulgence will be given if,
No.
if at all we will be able to establish contact, my lord.
Since 2020, you have not 4 years have passed. You have not been able to establish contact. WPC number 4180 of 2006. The counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the petitioner. नाम बताइए अपना.
My lord, my name is not in Wakalat.
Sorry.
My name is not in Wakalat.
I'm appearing this.
Okay. Yes.
Not in this case, the sole petitioner he has died. I believe for at least 4 weeks time, Lord, we shall coordinate.
No, since 2020.
Yes,
See, it is mentioned in the order sheet.
Not long
So
back
you have
also,
not.
we have communicated the same to the party.
Has he contacted you?
No, not yet.
So therefore, it doesn't make a sense. आप अपना नाम बताइए.
Ashish.
Counsel for the petitioner is present. He submits that the petitioner has expired and it has been recorded in order dated 25/11/2020 itself that sole petitioner has expired. He submits that he has not been able to contact the legal heirs of the sole petitioner and therefore no steps have been taken in the present petition. Considering in spite of best of his efforts, considering the fact that sole petitioner has expired way back and it has been recorded in order dated 25/11/2020, subsequently opportunity was granted to subsequently the matter was adjourned on 2/3/2021 also, so that steps could be taken to substitute the sole petitioner, but it appears that the petitioner has not been, the counsel for the petitioner has no instruction from the legal heirs and successors of the sole petitioner. In view of the aforesaid fact, the sole petitioner having expired, this petition is treated as abated. अपना appearance से दीजिए. Interim order सब vacate कर दीजिएगा. चलिए next call करिए.
Item 9 WPC 5252.
Serial number 7.
ऐसे बीच में मत पूछिए.
Oh, man. But
Yes, petitioner.
Not the earlier notices have been issued upon the
You
substitute.
kindly give your appearance in that case. Yes.
Notices were earlier issued upon the substituted legal heirs, but that could not be validly served with because as per the office report, on the very last date that has been received at the Nisar.
Where are these people living? 4A to 4D.
4A, they are living at Dumka, my lord. Para 3 I have stated, my lord, of my IA. That is IA number 8174 of 2017.
WPC number 5253 of 2006. The learned counsel for the petition commits that unserved notice to newly added respondent number 4A to 4D. Substitution was allowed.
My lord, that was
Has been received with the report of the judge in charge that the notice could not be served as the same was received just a day before 15/2/2018. Counsel for the petition is directed to take fresh steps for office is directed to petitioner committee. The office is directed to take it this way. Let notice be issued to the respondent number 4A to 4D through the concerned police station. The returned notices be issued to be used by the office for the purpose. Counsel for the state.
other private respondents.
Where is the state? State is not there.
The state is the party.
State is not party.
Party. Yes, my lord, state is party.
State is not a party.
I'm sorry, my lord, state is not a party. I'm sorry.
Post this case on 9th of January 25, awaiting service report. You go to the office and find it out. If there is any problem, you ensure that the notices are there. Envelope तो आया हुआ है
हाँ
सर?
वो तो आया रिटर्न है.
Item 10 WPL 6351 of 2006.
Let's say earlier.
Just a moment. 4A to 4D, right?
Not that is-
कौन आप हैं इसमें? 4A to 4D का डिटेल्स कहाँ पर है? IA में है?
हाँ IA.
IA नंबर?
IA number it is 8174 para 3 minutes.
8174 पैरा 3 में जो डिटेल्स दिया है ना वो ऑर्डर में लिख लीजिएगा, नहीं तो पुलिस वाला कहाँ ही खोजने जाएगा. ठीक है?
Item 10.
Let's say earlier notices were issued to respondent number 2, they were substituted. 2 has appeared, 3 has not.
3 has not appeared means you know what to appear, let them not appear. Who bothers about it? वकालतनामा नहीं आएगा तो केस नहीं टेकअप होगा. English translation of service report. Wakalatnama on behalf of respondent number 3 is on record. This is what it says. And Mr. B.B. Kumar had undertaken to file wakalatnama on behalf of respondent number 2.
But online there was not so.
Online it is not showing. B.B. Kumar has filed wakalatnama on behalf of respondent number 3. Respondent number 3 का नाम बताइए. Respondent number 3 का नाम बताइए.
I know
Ansari.
उन्हीं की तरफ से तो फाइल की. And both are full brothers. आइनून की तरफ से तो फाइल कर दी है. रिस्पॉन्ड नंबर 2 कौन?
Respondent number 2
Is Yunus Ansari. Both
Yes.
are full brothers.
Mr. I am playing any date will fix now.
डेट के अलावा आपको आता ही क्या है पे करना? नहीं करना है. 2006 का मैटर है. 2036 में फिक्स कर दो. जो भी लोग बचे हुए वो लोग भी सब खत्म हो गए.
It's in the coming week.
You have not seen the records. आपको कुछ पता नहीं. Respond number 3 has already appeared. Where is the service report of respondent number 2? Where is Mr. B.B. Kumar? बुलाइए उनको बुलाइए. There are two brothers, full brothers. One of them has appeared and the other is not wanting to appear. Yes? What is the reason? What is the nature of the impugned order? Full back wages.
Full back.
You are paid. Execution is going on. We will stay the execution. Execution is going on. पता ही नहीं है, आपको कुछ नहीं मालूम. Why would the workman not appear who has been granted full back wages by the court? Yes? नहीं पता. Who is the petitioner who does not give you any instructions? Bokaro Steel Plant. सरकारी काम ऐसे ही चलता है. With Mr. B.B. Kumar come, right? We'll find it out. थोड़ा लेट आते हैं वो आ जाएंगे. थोड़ा सा लेट आते हैं वो. 10:30 बजे नहीं आते. जनरली.
Item 11 WPC 5934 of 2007.
Petitioner? Miss, where is the petitioner? WPC number 5934 of 2007. As per the office note, the notice issued to respondent number 7A and 7B has been either served personally to them or through their close relative who are residing with them. Accordingly, the service of notice upon respondent number 7A and 7B is accepted as valid. So far as respondent number 7C and 7D are concerned, it has been reported that they have expired. The office note was prepared as back as on 16/11/2021. But no steps have been taken in connection with deceased respondent number 7C and 7D. Who is for private respondent? You are the purchaser. What is your status? You are the purchaser. Yes? I'm just asking you, are you the purchaser or the preemptor? Or the seller? आज नहीं पता तो अगला डेट में कहाँ से पता चलेगा? निकाल रहे हैं। कब का रिकॉर्ड है? पिटिशनर के वकील कौन है? आरसी साहू। कौन? Do you know him? is the purchaser of the property? Shivlal Mehto. Shivlal Mehto is not even a party in this proceeding.
Bhola Mahto is the purchaser, but it's respondent
Bhola
number
Mehto
4.
is the purchaser.
वहाँ के इंस्ट्रक्शन जगह प्रोग्राम के दिलाए गए
तो सभी मध्य होंगे ना, 2007 का है, कितना साल हो गया? हाउ मेनी इयर्स? हाँ, कितना साल हो गया?
24 और 7 17 इयर्स में
और प्रीएम्पशन कब फाइल हुआ था? वो भी देख लीजिए। '86, '87 क्या ही बचा है इसमें? And the petitioner is the preemptor. But then he is not the purchaser of the property. Hardly anything is left.
whether he how many persons are did or not I want to see instruction
कौन सी
70 साल में तो बहुत कुछ हो गया कितना
We do not know.
टाइम में भी
In view of the fact that the respondent number 7C and 7D were reported dead as back as on 16/11/2021 and no steps have been taken in connection with those respondents, the petition is treated as abated as against respondent numbers 7C and 7D. '21 में कुछ amendment भी फाइल हुआ। Pose this case under appropriate heading on December 9th, on 10th of December in the supplementary cause list. उस दिन नहीं आएंगे तो उनका केस DFD कर देंगे। प्रीएम्प्टर का केस कितना ही दिन चलेगा 86 का मैटर, राइट?
Item 12 WPC 857 of
अपना
2008
appearance
item
दे
13.
Give your appearance. You also find out कौन किसका क्या डेथ हो गया, क्या हुआ पता नहीं। Yes, petitioner. Sorry, yes. Who is there in WPC 857? Is it listed for orders?
Yes, madam.
Why is it listed for orders?
The state was required to inform your lordship about the other pending cases.
My order dated 8 March 2022.
Yes.
Leadership, my order dated 8 March 2022, there was a direction was given to the state to verify as to how many petitions have been offered against the order passed by the in settlement appellation. I pray for 2 weeks time, leadership, that has not been
was, we forget about it, how, what should we do? आपको भी कहाँ से पता चलेगा? From where will you come to know about it?
Leadership that has been communicated to the department leadership.
When?
The leadership 2 weeks time will be given so as so that will go to
टाइम लेने के अलावा आपको क्या चाहिए? इतना पुराना मैटर्स है.
his leadership, but it is coming.
This is
last-
going in the graveyard now. निकाले हैं वहाँ से. ये grave से निकाल लेते हैं.
On last occasion, leadership on 12th July 23.
There is a petition for ignoring certain defect. What is it? IA number 2213 of 2008.
Item 12.
I do not know.
That is
WPC 857.
857.
Yes.
I'm in the next.
Who is for WPC 857? Mr. Anil Kumar, Senior Advocate, was appearing. Where is MS Chandana Kumar? DK Prasad was also appearing. Wakalatnama discussed. लिखिए जरा WPC number 857 of 2008. IA number 2213 of 2008 has been filed with a prayer to ignore defect number 2 in regard to Annexure 6. From the records of this case, it appears that on 15 to 2012, the writ petition was admitted for final hearing. The Annexure 6 appears to be a typed copy, and the defect was with regard to filing of photocopy of Annexure 6. Since the petition has already been admitted, the defect in connection with Annexure 6, as pointed out by the stamp reporter, is ignored for the present. This is subject to any objection that may be raised by the respondents. You take care of Annexure 6. The Counsel for the State, this order has been passed in presence of Counsel for the State. Who shall take specific instructions in connection with Annexure 6. Consequently, IA number 2213 of 2008 is disposed of. या ये खत्म हुआ? और बताइए क्या prayer है? What is your
Lord,
prayer?
the petitioners had purchased a piece of land, my lord. When the survey agreement work was done, it is the case of the petitioners that by mistake the name of the state of Bihar was recorded as the owner of the land. Now they preferred a appeal before, they preferred a objection before the charge officer. He allowed it because the petitioners were bona fide purchaser in occupation of the land, and there was a direction for recording the name of the petitioners and the rightful owner of the land. Later on, the circle officer preferred an appeal against the said order. In the appeal was allowed on the ground saying that the land were under the notified under the Land Sealing Act. The additional collector took note of the fact that the owners of the land were never noticed in the land sealing proceeding, and he directed that if the deeds are to be, if the transaction is to be cancelled, issue notice to all the persons who were the purchaser of the land. So that did not happen. Now, so I am against the order in appeal as well as the notification as the order of the land sealing. This petition pertains to that issue. So in view of that fact, there was a direction that other cases be informed, because though that is not on record, but I have come to learn that the land pertaining to this area, the issue has been resolved, but that is not on record, and I also don't have the orders. But that this is basically the Namkin Chai Bagan area. That is literally been settled. I will have to also seek instruction whether there is a policy deviation or there is some order of court.
Annexure 6 is common in both. Annexure 6 is common in both the writ petitions.
The other writ petition I don't have. Common.
In both the writ petitions. उसमें दूसरा में क्या फोटोकॉपी लिखा है, टाइप कॉपी लगा है.
नहीं टाइप नहीं है, इसमें गैजेट नोटिफिकेशन है सेकंड.
Gazette notification is not Annexure 6. In the
in the
previous
second writ petition.
From third page, they are saying gazette notification has not been annexed in the first writ petition. Subsequent other pages are similar.
First page is typed and later on is the photocopy. You see, it's kind first page.
From page 15, the first writ petition, It is Annexure 7 edition. In first writ petition, Annexure 6 of second writ petition, and Annexure 7 of.
That's it. What about Annexure 6 of the first writ?
No.
No. My case, second case, Annexure 6 corresponds to Annexure 7 of the first. 6 these things are that is not in the second petition.
Even though reply has been giving it a counter revision with regard to.
इसमें जो है ना जो आईए है they say that the certified copy of Annexure 6 is an order passed in sealing case number 144 of 7374, and they say that record is not available and therefore they are not in a position to file it. Do you get that? आईए का जवाब फाइल करिए, आप आईए का जवाब फाइल करिए, ऐसे नहीं हो सकता। ऐसे टाइप कॉपी फाइल करके कुछ भी करके ऑर्डर थोड़ी हो जाता है।
Or
नहीं होगा।
maybe no specific statement has been given with regard to Annexure 6. It has been.
Just so please take it again, मतलब ये जो है ना case has been admitted, right? And the IA number such and such has remained pending. The Learned Counsel for the state is directed to seek instructions and file a reply to the interlocutory application with particular reference to the statement made in paragraph 2 of the interlocutory application, wherein it has been mentioned that the order that the petitioner could not get a certified copy of Annexure 6, which is an order passed in sealing case number 144 of 73-74 from the Court of Additional Collector Ranchi, since the record is not available in the Court of Additional Collector Ranchi. Right? If the a copy of if the records are traced out, a copy of the Annexure 6 be filed along with that. ठीक है? अभी आइए पेंडिंग ही रखिए, पता चले कि वो बोले ऐसा कोई ऑर्डर ही नहीं है. Possible?
Quite possible. Maybe possible.
This is happening in
Item 11.
857.
Sorry.
आपका बाकी सबका कुछ पता है. Counsel for the state also prays for some time to comply the order dated
8th March 2022.
8th of March 2022. The affidavit should be filed by 3rd of January. Post on 9th.
Item 14 WPC 3857 of
आप भी पता
2008.
करिए, आपको नहीं पता. You are not in touch with your client.
I have received instruction only yesterday, so I will discuss it.
एफिडेविट तो सिर्फ एक केस में होगा ना,
हाँ,
सेकंड
एक ही केस. सेकंड केस में कुछ साथ में होगा.
Lordship, due to notice matter, I have not compliance the earlier agreement.
What was the earlier order?
Earlier agreement directed petitioner to issue notice on legal, issue notice on legal years of respondent. But I have not compliance. We have for 1 week time now.
WPC number 3857 of 2008. Counsel for the petition submits that due to inadvertence, order dated 8/4/2024 could not be complied. He prays for and is allowed time till Tuesday to comply the order. Post this case on 9th of January, awaiting service.
Item 15 WPL 5120 of 2008.
Notices were issued upon respondent number 1 and 3. The notice with respect to respondent number 1 came back saying that the respondent number 1 has died. Thereafter, respondent number 3 was issued notices on the last day. And again, the notice has been returned saying that it is not proper, correct address of the respondent number 3.
What is the relief you are?
Minimum Wages Act, an application was filed by the respondent number 1, the workmen, through the respondent number 1, and that was allowed. So we are aggrieved by the order that was passed, and also we have prayed for falling upon the records from the lower court division. But if the respondent number 1, Jagtar Singh himself has died in relation, then he needs to be substituted.
So when did he die?
On the last date, I just perused the record in relation. It says that he has died, but we do not have knowledge about the legal heirs in relation. Because it's a case of 2008. We have written a mail yesterday to the company informing them of the update to see if they have any information. The son had informed that he
What
has
is the
passed
last
away.
date?
6/2/2024, Your Ladyship.
This is fresh notice to respond number 3.
And for respondent number 1, it says that respondent number 1 has died. The son has informed that the respondent number 1 has died.
You have taken steps for respond number 3?
Respondent number 3, yes, Your Ladyship, that
Has
has
he
also
appeared?
come back. No, Your Ladyship, it has come back that the address is wrong of the office that is served. The office has shifted somewhere else. But where it was not informed as per the records.
See, earlier also, so you must have taken steps at fresh and new address. You are taking steps at the same address.
So it has been
Yes.
taken at the same address.
Why? When there is a clear note that it has been shifted to another place,
Of the another place, Your Ladyship.
you are go for paper publication if you don't have any knowledge of. And what about respond number 1?
I have written a mail yesterday asking them, Your Ladyship, but since it's 2008 matter, I think they will also not have information regarding this.
So in a minimum wages matter, you have made the case in front of us, practically. Right? Isn't it? How much is the amount involved? Fighting for this minimum wages?
It is annexure 3, they have annexed 17,445, 21,800, 29,586, 39,411. Total of this into 3 as compensation as well. But the jurisdiction is in question, Your Ladyship. He did not have power, and also in the impugned order itself, it has been recorded that no evidence was reduced. Just because there was absence of evidence, they have said that since it's a long pending case of 14 years, we are allowing it. There is a clear-cut recording in the impugned order.
If you do not take steps against respondent number 1, the order stands abated. Right? The writ petition stands abated.
I will just seek instructions from the client, Your Ladyship. I've informed them yesterday. 1 week time may be granted so that I'll take appropriate instructions, inform them of the status. That if there is any possibility of arriving at any information or finding out. And in the meanwhile, I'll do paper publication for
Respondent number
3.
1 is Jagtar Singh. What about this Siddheshwar Thakur, Pankaj Kumar Singh, Bahadur Singh?
Yes, Your Ladyship.
They are not party before this court.
And Your Ladyship,
Let me just understand. Are they party before this court?
Your Ladyship,
You have not made them party.
And Jagtar Singh is also being represented through the secretary. And as per that, it is not clear whether we have furnished.
We do not know.
Yes,
See, you have made Jagtar Singh as party. Why have you not made others as party? They are not party before this court. Please don't file an amendment petition. We will not permit this. There are 4 workmen. Jagtar Singh has expired, regarding which you don't have any instructions. Right?
But,
So far as others are concerned, they are not party before this court. How do we pass an order against them in their absence? Which company is this?
Indian Oil Corporation.
So they are assisted by legal luminaries, as I understand. They are only agreed by Jagtar Singh's order. They are not agreed by anybody else. Please do not say that because of inadvertence they could not. I will not permit this.
Take instructions.
No instructions. I will just record it. No.
One
No,
indulgence
no,
may be
no.
granted. Only yesterday, Your Ladyship,
WPA
I've
number
gone through the
5120
file.
of
Your
2008.
Ladyship, I'm only praying for one
When the counsel for
indulgence.
the parties are present, from the perusal of this records, it appears that the minimum wages with compensation
Your
has
Ladyship.
been fixed by the impugned order with respect to 4 persons, namely Jagtar Singh, Siddheshwar Thakur, Pankaj Kumar Singh and Bahadur Singh. However, in the writ petition, only Jagtar Singh has been made party as respondent number 1, and so far as other 3 are concerned, they are not party. It has been submitted by the counsel for the petitioner that the notice issued to Jagtar Singh has returned unserved as he was reported dead by his son. This office note is dated 5/9/2023. However, no steps have been taken by the petitioner as against in connection with Jagtar Singh. Since other 3 persons are not party in the present proceedings, the impugned order has attained finality so far as the remaining 3 persons are concerned.
Your Ladyship, I'm only praying
Counsel
one
for the
indulgence.
petitioner seeks adjournment. अब बताइए क्या होता है?
I'm only seeking one indulgence.
बस हो गया इंटेलिजेंस. बताइए आपको कितना दिन के बाद का टाइम चाहिए?
2 weeks time, but that part of
No,
the
no,
order
no.
may be reconsidered.
Minimum
Only
wages
praying
may this company will not pay minimum
for- Your
wages
Ladyship,
also.
but the impugned order itself
We will see
is
that.
perverse.
We do
Your
not know.
Ladyship.
You have not made them party. The order has become final against them.
Your Ladyship, but through the General Secretary, and we have challenged that whole order, Your Ladyship. We are not challenging part
No.
of the order, Your Ladyship. Our prayer is
You have
for
made
challenging
only
the
Jagtar
order.
Singh as party.
I will just take instructions, Your Ladyship, and peruse the records, Your Ladyship.
Post
Only
on
one
11
indulgence.
December under the heading for orders. जो करना है करिए.
Item 16, WPL 5047 of 2009.
Petitioner. ये क्या ऑर्डर्स में है? Why is it for orders?
let's say it's IA है इसमें extension of time
देखिए WPL number 5047 of 2009 and in IA number 954 of 2023 has been filed seeking extension of time to deposit an amount of rupees 1 lakh. The petition was filed on 30/1/2023, praying for 2 weeks' time. Two weeks has already expired. But neither anybody is appearing on behalf of the petitioner when the case is called out, nor anything is mentioned in the office note with regard to deposit of rupees 1 lakh. However, time till Wednesday is granted to the petitioner to comply to deposit the amount of rupees 1 lakh. Failing with this, petition will stand dismissed without reference to appeal. Maybe the petitioner absent. If the amount is deposited within time, post this case on Thursday. But Thursday and Friday in the supplementary cost list. ये order थोड़ा urgent है इसको upload करना.
Item 17 WPL 6670 of 2020.
I am appearing for respondent number 1, 2 and 3. The writ itself is only misconceived. The petitioners say they are the retired employees of Tata Steel, and while in service they became members of a employees cooperative society, wherein they deposited certain money which they are not getting back. 1, 2 and 3 are the officers of TISCO. They have nothing to do with that society. And if it is a private cooperative society, then the remedy lies under the State Cooperative Society Act if it has been formed under the State Cooperative Society.
But why is it listed for orders?
Maybe for notice, Your Lordship. I have instructions to appear.
When the notice was issued, you did not point out all this.
So I am appearing, I am pursuant to notice, I have instructions to appear on behalf of respondent.
You are representing respondent number?
1, 2 and 3.
1, 2, 3.
Tata Steel has not been made a party, only the officers by designation has been made.
1, 2, 3 validly served. Respondent number 4 denied. Respondent number 5 denied.
4, 5,
6 also refused to take notice.
6 is the government authority, Lordship, Registrar Cooperative Society.
Okay. As per the office note, the counsel for the respondent number 1, 2 and 3 is present. As per the office note, respondent number 4, 5 and 6 refused to take notice. Respondent number 6 had stated that, while refusing, has stated that the society has been shut down. ये लिखा ही हुआ है यहाँ. Nobody appears on behalf of the petitioner. Counsel for the respondent number 1 to 3 has submitted that the writ petition itself is misconceived. And the petitioner is seeking remedy in connection in the capacity of being member of Cooperative Credit Society.
Yes.
TISCO workers within bracket employees bracket close Cooperative Credit Society.
No. They are the ex-employees of Disco as per their as per their allegation.
They are seeking relief against this society only.
Yes, only this society. Yes.
Right? He submits that the petitioner, the grievance, if any of the petitioner, they have a remedy under the provisions of Cooperative Societies
Yeah,
Act.
cooperative, yes.
And no relief has prayed for be granted to the petitioner in this writ jurisdiction. आज कौन सा दिन है Wednesday? Pose this case on as Tuesday. Pose this case on Thursday in the supplementary process. Under the heading for admission, it will come. Under the heading for admission. वो जो 3 लोग का है ना, is accepted as valid. Service of notice upon them is accepted as valid. Refuse कर दिया ना तीनों.
Item 18 WPL 6910 of 2023.
Petitioner.
Excuse me, Lord. I have to issue me, Lord. I have filed me, Lord. Against the order of Lord. That will be stayed me, Lord. Can you have a look at it, sir? 1 page 18. I will. Consider it that this problem filed of our petition so called mentioned that the OP has already filed writ application in which applicant be reduction has already been appeared.
No, you have not taken. Whom are you representing?
Respondent number 1.
You have not taken steps for service of notice.
So that is I have taken a statement.
कहाँ?
I have taken a statement.
When did you take step? ऑफिस नोट बिना देखे मत बहस किया करिए. ऑर्डर्स में आया मैटर, मेरा काम नहीं है ये. You just have a look at the office note. कुछ नहीं, आप जरा देखिए पहले ऑफिस नोट. अभी डिसमिस करते हैं ऑफिस. You just read the office note. चेक करिए, हो सकता है हमसे भी गलती हो समझने में. चेक करिए. कॉल करिए.
Under heading for admission, item 19 WPC 2899 of 2018.
Yes, petitioner. What is this?
This is, I was playing for some time because I could not prepare. This is with regard to certain payments made for the sale of hairwood to the corporation. Now they are saying that you are not entitled to receive any money because the tree did not belong to you. You are an intermediary. This is a prohibition on the payment to intermediary. This is the sum and substance of the matter. Under the Act, according to them, there is a prohibition on payment of price for sale of hairwood to the corporation. Hairwood will be sold by the government-owned corporation, and I can't. That is the sum.
So you are the intermediary.
Intermediary. I am relying upon agreement, but as I know if there is a prohibition, I'm fully aware. If an agreement contrary to the law, the agreement is a nullity. I will know. But there was something I remember arguing this matter 2-3 times, but yesterday I could not prepare for another session. So next week also.
Otherwise, it is ready.
It is ready, completely. It has been argued 2-3 times before different.
Whom are you?
Mr. Rupesh Singh appears.
For behalf of Mr. Rupesh.
Sorry?
Mr. Rupesh Singh also appears, not? So it is otherwise ready. It can be argued, not? Next week there is a medical problem in my family, so can it come the week next?
What happened?
No, my wife has to undergo a gallbladder stone operation on 5th. So the only thing was if at all the week commencing 16th it can be kept.
16?
Because after surgery, 5th is just the weekend, so I
Have you
don't know.
prepared your notes? Both of you?
Yes, I had a note notes prepared and I don't know whether I had given a copy. I'll prepare it afresh
I
and
think synopsis. This is
no,
just a
I
synopsis.
had prepared a short note like this.
आपने देखा
This is a very small question of law, my lord, for me to ask.
वो नोट हमको भी दे दीजिए 16th को रखते हैं
हाँ 16
16th को
My lord, I have an engagement on 16th.
70
17th.
WPC number 2899 of 2018. The learned counsel for the parties are present. The counsel for the petitioner submits that he has furnished a note with the consent of the in connection with the case. The counsel for the petitioner submits that a short question is involved in the present case as to whether the sale proceeds of Harewood could be claimed by the petitioner, who is the intermediary. With the consent of the counsel for the parties, pose this case for final disposal on 17th. कौन सा एक्ट लगेगा इसमें?
ये एक्ट फॉरेस्ट प्रोड्यूस रेगुलेशन ऑफ ट्रेड एक्ट 1986
बिहार
फॉरेस्ट प्रोड्यूस विदिन ब्रैकेट रेगुलेशन ऑफ ट्रेड एक्ट 1986
Act 1984.
Yes.
Counsel for the parties have submitted that the case would be governed by the provisions of Bihar Forest Produce within bracket regulation of
Trade.
trade bracket close Act 1984. Final disposal to be taken up by 215.
I'm sorry. Actually, our supplementary case list minus item number 6. I was in my humble submission that
What has happened in that case?
eh?
What has happened in that case?
ऑर्डर हो गया उसमें अभी लिख दिया कि हम लोग जो है पिटिशनर हैं उसमें और जो ऑर्डर हो चुका था रेट पिटिशन में रेस्पोंडेंट रिव्यू पिटिशन फाइल किए माय लॉर्ड्स हैव बीन प्लीज्ड टू अलाउ द रिव्यू पिटिशन which had liberty to the respondent petitioner to file petition for substitution of the legal heir in the writ petition. They did not file. Now, in my humble submission,
You are the writ petitioner.
we are petitioner.
Writ petitioner कौन है?
We are writ petitioner. Order was passed in our favor.
हाँ ठीक है, रिकॉल हो गया. उसके बाद आपने रिट पिटिशन में क्या किया? कुछ नहीं किया.
Actually, today when this matter was listed,
ये
today.
पहले भी आया था एक दिन और आया था. उस दिन भी कोई नहीं
हाँ,
आया.
मैं फेयर नहीं कर रहा है ना उसीलिए
कोई बात नहीं सर, हम लोग क्या ही कर सकते हैं. आप इस ऑर्डर को आप फिर से आप अपना लीगल हियर आके अपना फाइल करेंगे. हम लोग क्या ही कर सकते हैं. डेड पर्सन के अगेंस्ट में कितना ही हम लोग मूव करेंगे.
डेट पर्सन के केस में नहीं हुआ.
All the 3 petitioners have died, correct or not?
हैं?
All the 3 petitioners have died.
When the judgment was delivered by the law.
अरे भाई आपके रिव्यू पिटीशन में लिखा हुआ है आफ्टर हियरिंग यू, राइट, that all the 3 writ petitioners have expired, isn't it?
Yes.
So
Now in the
who will take steps?
And in the same order, Lordship had directed the petitioner of the review petition.
No, रिव्यू पिटिशनर का तो कोई डायरेक्शन नहीं होता है सर. आपका कुछ भी होगा सर. आपका रिट पिटिशन है. You are to represent the legal heirs. कैसे हम लोग रेस्पोंडेंट को बोलेंगे कि आपका सब्स्टिट्यूशन फाइल करने के लिए?
उसी रिव्यू में ही जो ऑर्डर
नहीं नहीं, ये सब गलत लिखा हुआ है.
गलत नहीं बोल रहे.
कोई बात नहीं. अब ऑर्डर हो गया आपके एब्सेंस में, आप अपना पिटिशन फाइल करिए.
एब्सेंस में ऑर्डर कर दिया कि अबेट हो गया.
करिए, अबेट हो गया. रिट पिटिशनर, ऑल द 3 रिट पिटिशनर्स आर डेड. तो क्या ही करें हम लोग? किसको खोजने जाएंगे बताइए? हम लोग किसको खोजने जाएंगे? When all the 3 रिट पिटिशनर्स हैव एक्सपायर्ड, तो कहाँ हम लोग क्या ही कर सकते हैं बताइए?
उसमें रिव्यू में जो ऑर्डर
आप
किया
अपना पिटिशन फाइल करिए, तभी वो ऑर्डर फिर से रिवाइव करेगा केस. रिट पिटिशन ऐसे नहीं कर सकते
एट दिस स्टेज.
नेचुरली. यू आर द रिट पिटिशनर्स. आपने कंटेस्ट किया है रिव्यू पिटिशन में, सारे लीगल हियर्स को पार्टी बनाकर सब लोग को अपीयर कराए हैं. इट वाज सो डिफिकल्ट, आई रिमेम्बर. जब केस टेकअप होता है तो आप लोग को होश ही नहीं रहता है कौन मर गया कौन जी गया. यू आर्ग्यू द केस. without substitution. The private respondent had already expired when the writ petition was argued.
Private respondent appeared in the writ petition.
But when the case was argued, he had already expired. And because of his expiry, this happened. And during the pendency and subsequently, maybe after the order in the writ petition, all the three petitioners have also expired.
May I pray one thing for subject to my lord's
No,
kind?
sir.
May I pray one thing? If lordship give one indulgence to
नहीं
us,
सर, बाद में हम ऑर्डर नहीं रिकॉल कर सकते. These are all recorded proceedings. हम
no,
ये
that
नहीं
has
कर
not
सकते.
been signed. My lord has passed on.
नहीं सर, कुछ नहीं कर सकते.
हैं?
आपको कोई इंस्ट्रक्शन नहीं है, कुछ पता नहीं है, क्या ही हम लोग करेंगे बताइए.
तो मार्क नहीं कर सकते.
कोई
भाई प्रॉब्लम है, मार्क नहीं कर सकते. यहाँ पर हाई कोर्ट में आए तब देख रहे हैं कि हमारा नाम फ्लैश कर रहा था, तब आकर
आपका नाम तो नहीं फ्लैश करना चाहिए था. हाँ.
उसका नाम फ्लैश कर रहा था, दौड़ करके
उनका
आई.
नाम तो लिस्ट में अपीयर कर रहा है ना.
Not a pity.
तो कोई बात नहीं, बहुत ही अच्छी बात. Now you do not have the वकालतनामा also because all the three petitioners have expired. आपको क्या ही लोग कैसे बोलने का बताइए. All the three petitioners have expired. Your वकालतनामा is not surviving anymore, and they are quite aware of the matter because they appeared in the review petition, isn't it? They are aware कि writ petition revive कर गया है. मालूम है उन लोगों को, क्या ही हो सकता है.
ठीक है.
कोई बात नहीं सर, सबका रेमेडी है. अंडर द लॉ एवरीथिंग हैज अ रेमेडी. वो लोग आ जाएंगे, उनका तरफ से आप पिटीशन फाइल कर देंगे, हम लोग सुन लेंगे. इसमें क्या ही करना है, रिव्यू नहीं करना पड़ेगा सर. आपको उसको आई डू नॉट नो क्या करना पड़ेगा. आप देखिए. हाँ,
एलपीए करना पड़ेगा.
एलपीए किसके अगेंस्ट करना पड़ेगा कि डेड पर्सन के अगेंस्ट में हम केस डिसमिस कर दिए, इसीलिए कौन किसके अगेंस्ट में आप एलपीए फाइल करिएगा.
अच्छा, एग्जामिन कर लेंगे.
Same in my case also, your lordships have held that one of the respondents had died and therefore abated. But he was representing it was being represented through the union.
No.
Before the tribunal also it said so and so, three others represented through the union, and therefore the cause title
No,
was.
but you have not made them the union as a party. You have made
But
him as a party.
I have made them a party as they were in the tribunal, and therefore no defect and all these proceedings have happened. All over the period of 14 years, more than 16 years. That's the reason.
Then file an affidavit. अभी तो झूठ मूठ कर मिनिमम वेजेस में कितना परेशान करते हैं.
नहीं, appropriate jurisdiction or appropriate government con. I know you have heard, Mr. Lordship, keep it on 11th, but I'll satisfy you. The Lordships have kept it on 11th, and I'll come and ask that it is not important. Simplicity at 11th for a because this will not be, it can't abate. If I made the union, then the defect would have been.
Abate नहीं बोले हैं. I have not stated that it has abated. I have simply stated that three of the persons who were beneficiary of the order,
Correct.
they have not been made party.
Not required because but the order says that this case has been filed by so and so and three others through the general secretary so and so. And I have also made Jagdeep Singh through the secretary. That was the cause title.
You have made Jagdeep Singh through the
secretary.
Through the secretary. Jagdeep Singh is not the secretary.
No, that is how the cause title was mentioned there, and I cannot change the cause title. It would have been a defective case. And therefore, for all these years, no defect was pointed out. Court has also accepted the position. Notices were issued.
You see, you made Jagdish Singh as a party.
Through the secretary.
So
the
Jagdish Singh was one of the workmen.
That is how they made the cause title. An error was on their part. I could not have changed the cause title in a proceeding arising out of that. That's my difficulty. I know what your lordship is absolutely right. The error is on the part of the original court proceedings. That I can't rectify here. I can only make.
See, respondent number 1 has expired. No petition for substitution has
not
been
required,
filed.
because it's the secretary who is to represent. Secretary Singhbhum Labour Trade Union. That's what I can find out.
Why have you made? You have not. You have made Jagdish Singh as a party.
Represented by the secretary.
That's right. A dead person being represented by a secretary will continue as a party in this case.
No, your lordship is, but it will not abate. I will then.
I have not stated that it has abated. I have simply adjourned and also stated that these three persons have not been made party.
No, your lordship. What I'll do is 11th. I'll file an application.
You file an application.
Whatever appropriate application is.
Yes, you file your application.
Great.
क्या हो
एक दो दिन के करीब वेरीफाई करने के लिए सर
इसमें वेरीफाई क्या करना है?
हम देख लेते हैं, हमको याद है कि हम कुछ करवाए हैं.
दिखाइए, अभी चेक कराते हैं. रिट में जरा देखिए तो इनका नोटिस अभी चेक कराते हैं ना सर. आपको जो याद है हम लोग का रिकॉर्ड में मेमोरी में रहता है.
ठीक है, मेमोरी में, लेकिन हो सकता हो कि कहीं हमारा क्लर्क कैसे किया क्या. थोड़ा सा हमको देख
ऑफिस नोट भी तो नहीं देख रहे ना आप लोग,
नहीं तो
चेक करिए जरा नोटिस फाइल हुआ कि
वहाँ हमको शो नहीं कर रहा है, लेकिन वो हमको याद है कि उसमें हम किए हुए हैं, कैसे नहीं कर रहा है।
सर,
हमको
जो
एक
चीज़-
दिन का समय दीजिए।
कोर्ट कचहरी मेमोरी से नहीं चलता है सर, मेमोरी से नहीं चलता, कोर्ट कचहरी रिकॉर्ड से चलता
हाँ,
है।
उसमें ऑर्डर भी हुआ था कि इसमें अगेन नोटिस सर्व करिए, हमको याद है।
आपके मेमोरी से नहीं चलता है सर, कोर्ट का अपना मेमोरी सिस्टम है, एंड अनलेस इट इज रिकॉर्डेड इन आवर कंप्यूटर सिस्टम, आपका मेमोरी से नहीं चलेगा।
एक दिन का हमको समय दीजिए।
लेकिन इसके 11/6/24 का ऑर्डर से उनका कंप्लाइंस में नोटिस फाइल नहीं हुआ है।
नहीं हुआ है।
उससे पहले
देखिए WPL नंबर 6910 of 2023। In spite of order dated 11th of June 2024, no steps have been taken for service of notice upon respondent number 2 at his present and current address. When the case is taken up today, the learned counsel for the petitioner submits that, as per his memory, some steps were taken. However, from the records available in the computer system, filing of notice is not reflected. At this counsel for the petitioner prays for time to comply the order. Time till Monday is granted to the petitioner to comply the order dated 11th of June 2024, failing which this petition will stand dismissed without reference to the bench. If the notices are filed within time, post this case on 9th of January 24, awaiting service.
Item 20, WPC 4406 of 2018.
Petitioner,
What's the matter relates to the management of the Waqf property. Now, a committee was constituted. I'm just broader aspects of the matter.
is it for orders or it is for admission?
Admission.
Who is for the respondent?
I'm for respondent, private respondent. They are challenging basically an order of the Commissioner Santhal Pragna, which is at
Yes,
page
yes,
number
that was the
45.
impugn order.
That is the impugn order. The land comes under the
petitioner argument ही लेकर
नहीं थोड़ा समझने दीजिए, क्या वक्फ का प्रॉपर्टी है तो थोड़ा समझना पड़ेगा ना।
Exactly.
अब तो jurisdiction का भी बहुत बड़ा इश्यूज है, इसलिए थोड़ा समझना
I for the Waqf Lord. When the case was filed, the board was tribunal was not functional. Now the tribunal is functioning, Lord. They have alternative.
If it is, no, my lord, if it is,
By humble submission, Lord.
if it is a Waqf property done, but if come under the purview of the Santhal Pragna Tenancy Act, my lord, the Waqf cannot, ultimately, my lord, they are in connivance with the petitioner, they cannot claim a government land to be a Waqf land. That is the issue, which has been dealt by the courts, means the courts who have adjudicated the matter. The revisional court, my lord, under the Santhal Pragna Tenancy Act, my lord, the regulation is very clear that at the revisional stage, my lord, all the orders passed by the subordinates can be revised. So the commissioner has come into the position to hold that. That is at page number 45, my lord, may come. The deputy, may I just go through?
No, just a moment. How was it declared to be a Waqf property?
That is.
Where is it?
Now, it is 3 points are there, Lordship. That's there. Number one, it's a registered with Waqf property. Waqf under the Waqf Act, it is registered. Now the Waqf board is also.
Registered when?
It is in
1985.
1985 registered, but in the document which I have annexed, that is Khatiyan of that. In that Khatiyan also mentioned it is Idgah. Idgah cannot be a private property, and the nature of the land is Idgah. Idgah उसी में मजार भी है, और ये जो है I'm just referring. That's why I'm saying, Lord.
तो इनका वर्क प्रॉपर्टी कैसे बन जाएगा?
हाँ, इनका प्राइवेट प्रॉपर्टी कैसे होगा? दैट इज
नहीं, वर्क प्रॉपर्टी कैसे बन जाएगा? पहले तो ये बताइए।
वर्क बाय यूजर है ये, वर्क बाय यूजर है। इवन फॉर द सेक ऑफ आर्गुमेंट, इफ आई एडमिट्स दैट कि अगर वो उसका डॉक्यूमेंट नहीं है बट रजिस्टर्ड विद द वर्क, that work by user हो सकता है, that I have gone, the judgment is also of the Patna High Court, I am referring that judgment also. तो इसमें dispute
वर्क बाय
नहीं।
यूजर का क्या मतलब?
आप अगर टाइम मेमोरियल आप रिकॉर्ड ऑफ इसका खतियान में भी दर्ज है कि ये ईदगाह है एंड इसका जो है सो वहाँ मजार भी है और उस पर सारा मैनेजमेंट वक्त के थ्रू ही मैनेजमेंट कमेटी बनती रही है और उसका मैनेजमेंट होता है।
टाइम इमेमोरियल मतलब 1947 के पहले?
नहीं, वो तो पहले का वो तो चला ही आ रहा है, तो वही आ रहा है।
वो तो
इसमें
वहाँ पे तो ऑलरेडी मजार है।
हाँ, मजार है, ये एडमिटेड पोजीशन है, द डॉक्यूमेंट इज आल्सो देयर।
मजार कैसे वर्क प्रॉपर्टी बन जाएगा?
मजार इसलिए मजार तो ही वक्त प्रॉपर्टी हो सकता है। मजार है, मस्जिद है, मजार है, ईदगाह है।
एक्ट सब लेके आइए।
मैं जस्ट असिस्टेंट
ऐसे हम इसको ट्रिब्यूनल में भेजेंगे भी नहीं।
मैं जस्ट
हाँ, बिल्कुल ट्रिब्यूनल में
there is a
भेजेंगे।
voice, there is a, my lord, as per the act, the Waqf board, my lord, if my lord will go through the Waqf act, they have in connivance with the petitioner, my lord, they have violated the mandatory provision of the Waqf act, wherein the person who is doing the Waqf or the registration is being done, they have to bring and record where is the Waqf deed, who is the donor, who has dedicated the property. And
so this property could not have been donated.
Not at all,
because it is absolutely in public use.
And
it cannot be appropriated by anybody.
That is why it is work property.
That is the
both are using the same judgment. May I just
judgment
हमसे पैरा 9 भी देखते हैं ना, हम पूरा ही जजमेंट पूरा एक्ट भी देखेंगे।
मैं just act भी दिखाया आपको। May I just make two submissions, my lord, before the judgment, if my lord allow. The same document which my learned friend is making a reliance, that is at page number 6 of the supplementary affidavit, my lord. Page number 6. Just have a look, my lord. They have filed in the month of December 2019. This is the copy of a parcha, my lord. This is the khatiyan what my learned friend is relying upon. And the Kisim Rayat.
Just a moment. Yes, हमको जरा पहुँचने दीजिए डॉक्यूमेंट। Supplementary act.
Yes, my lord. December 2019. Barred by section 20 of the SPT Act.
हाँ बताइए, इसमें कौन सा डॉक्यूमेंट?
Copy of a parcha, my lord, has come in that.
Page number?
6, running 6. Their document.
भाई इसका आप टाइप कॉपी फाइल करिए, आप ऐसे डॉक्यूमेंट फाइल करके नहीं छोड़ सकते।
टाइप कॉपी फाइल किया हुआ है
इसके साथ
टाइप कॉपी है।
The same document I have also annexed with the type copy, my lord.
अच्छा।
Counter affidavit.
इसमें
that is at page number 20.
What do you want to say to
I
this?
just want to say that this document wherein my learned friend is relying, it's a Ganses plot, my lord. First, which comes under the SPT Act. Second, the Kism Rayat is there, my lord. The Ganser, at that instant, my lord, the person whose graveyard is there is my ancestor. I am Shah. Maghdum Shah is there, who is embedded there. So my ancestor is there in my own property. And here, my lord, the Rayat's name are also there. Maniruddin.
So according to you, it's a private property.
Yes, my lord. And moreover, it is not. It is a Gair-Majurwa land, which has been settled in to my ancestors by Kansas.
And it is not a case that it is an abandoned area.
Exactly. And what the Waqf Act, that is the
आधा दिन देंगे आपको।
उसी में सर्टिफिकेट में जरा देखा जाए, इसमें प्लॉट, जस्ट वन प्लॉट इज देयर अंडर द डिस्प्यूट, 1882 recorded as Idgah. That is the Idgah. That at page
6.
Yes, annexure 7 at page 4 of my supplementary affidavit. That the only one point plot is there, 1882. That is Idgah.
So therefore, if there is a dispute in connection with the property, whether it will fall under works property or it will not fall under that property,
Section 6
who will decide it?
Section 6 is clear. Tribunal will decide. Dr. Kindly, Section 6.
That is there, that is
Section 6
there.
is there. Only have a look at Section 6, Lord. I have just.
If there is a dispute regarding the title, then the tribunal has power to decide that issue.
That is
I'm not disputing that. But so far as this record is concerned, therefore I'm referring that the SDO has passed the order in their favor. Now the Deputy Commissioner has set aside that
This
order.
Waqf Act has come in 1995.
Yes, Lord.
This will have for all the transfers or whatever records which have been created prior to that.
Prior to that, Act was 1954. Thereafter, this Act has come. Now, amendment has come in 2013 itself. All those things are there.
Section 36.
Section 6, Lord, kindly have let him see. I am addressing the time.
One by one.
Section 6, Lord, kindly have a look at that. Dispute regarding work. If any question arises whether particular property is specified as work property in the list of the work is work property or not, or whether a work specified in such a list is Shia work or Sunni work, the board or the mutawalli of the work or any person interested therein may institute a suit in a tribunal for the decision of the question.
Is it enlisted as a work property?
Yes, registered as a work property.
Registered as a
Registered
work
as a work property. In the list of the work part.
A number is there, registration number is also there.
Therefore,
As a work property.
this provision bar and section 85 is very clear. Section 85. Let me finish. Section 85, not section 85. Entire proceeding of revenue code is null and void in view of the section 85 of the Criminal Act.
You are also challenging the order.
No, I am not. I am supporting the petitioner in this case because it is a work property and he is saying it is private property. And Idgah, Karbala, those things are, even if it is not dedication, for time immemorial, it will be a work property. As per the judgment passed on Patna High Court.
No, where is that provision under the Work Act?
Section.
Under the provision of Work Act, it must be there that Idgah and all these things will be treated as work property.
That section 54 has been interpreted as
Section
Mullah law is clear.
Muhammad
law, Mullah is clear.
Now the act is there, man. Section 36 will speak everything, man. Section 36.
188 of the Muhammad law, Mullah Waqf by Imam Murid.
जब एक्ट है तो एक्ट से चलेंगे ना अभी मुल्ला में कहाँ पहुँच गए?
नहीं जजमेंट उसी को डिफाइन किया है.
Section 36.
Yes, may I read, my lord? Yes, my lord. What are the ambiguities in the thing? Registration.
Yes.
Every waqf, whether created before or after the commencement of act, shall be registered at the office of the board. Secondly, application for registration shall be made by the mutawalli. Here there is no mutawalli as per the petitioner's abatement, provided that such application may be made by the waqf or his descendants or a beneficiary of the waqf or any Muslim belonging to the sect in which the waqf belongs. The application for registration shall be made in form and manner and as such place as board may by regulation provide and shall contain the following particulars: description of the waqf property sufficient for identification, the gross annual income from such properties, the amount of land revenue, cess, rates and taxes annually payable in respect of the Waqf Act, the estimate expenditure annual incurred in realization of the income of the properties. E are the salary, my lord. Important is 4, my lord. Fourth, every such application shall be accompanied by a copy of Waqf deed, or if no such deed has been executed or a copy thereof cannot be obtained, shall contain
if such deed has
full, full, may I read again, sir? Deed, or if no such deed has been executed, then again, or sir, a copy thereof cannot be obtained, shall contain full particular as far as they are known to the applicant or the origin, nature, object of the work. Now the question to myself is, my lord, if I am questioning myself, that petitioner show me a single sheet of paper or by averment as to my ancestors or their ancestors have dedicated the property, description of the property, and who is the mutawalli. It's an open and shut case and be out of the court.
I just
That's
whether the procedure as per the Work Act has been followed or not.
no.
Is according to you it has not been followed? Is the subject matter of inquiry, right? According to you. But once it has been registered, registry कैसे होता है?
on the basis of something.
नहीं, on the registry office में registry होता है.
नहीं वक्फ बोर्ड
Work board register करता है, work board.
Just a moment. Once it is said to be registered under the Waqf Act with the Waqf Board, who will scrutinize whether the required procedure has been followed or not? You see,
Yes, my lord.
it is a case, admittedly, they have got it recorded. If it has not been properly recorded, we will record your submissions to that effect. That clause, this particular section has not been followed. But this scrutiny as per the Act has to be done by the tribunal only.
May I just answer to your lordship's query?
Yes. How will this court come to a finding?
That is what is under challenge.
Therefore, if the tribunal comes to a finding that this required procedure has not been followed, then they will have no option but to declare that it is not a work property. We will say that this is required to be answered by the tribunal. They cannot ignore it.
No.
But
Yes.
this scrutiny has to be done by them,
May,
and then the consequences would follow.
yes, my lord. Indeed, I agree with your lordship's view, but may I just place two things, my lord. First, I nor my learned friends can deny that the land comes under the SPT Act. There is a Kansas land, my lord. Secondly, my lord, under the SPT Act, my
They
lord,
will also consider what will be the consequence of this particular property, particularly when it is situated under this and is covered by SPT Act. Even that is also required to be considered, and whether this property could at all be transferred to Waqf Board is also something which is to be considered, because under the provisions of SPT Act, the property belongs to the community. Simple. It is absolutely non-transferable, right? Isn't it? So these are the issues which we will have trust on the tribunal, right? We will record that these are the issues which are required to be considered by the tribunal, but this court will not consider it at the first instance. And how can this particular aspect of the matter, once the property is already mentioned as work property, then that whether it is proper, whether it is following the procedure of law, whether in spite of it will be in two legs. First, whether the procedure has been followed or not. And if the procedure has not been followed, you have a foolproof case, no problem. But if it is held that the required procedure has been followed, then under such circumstances, they will also have to consider whether on the basis of this SPT Act, whether this could have been at all entered into in the register. These are the two issues which will fall for consideration before the tribunal.
my lords,
And then you have the writ.
Yes.
Because otherwise there is no other remedy.
my lord, under the, I may be wrong, my lord.
No, we are not saying that you are wrong. We are trying to understand the contours, whether we can decide this issue.
Yet, may I just address your lordship? Under the Santarpala Settlement Regulation 1872, my lord, Section 5 is very clear, where the authorities have been given power to adjudicate the rights also, my lord. First, so at the first instant, my lord, the order which is also on record, the learned SDO, my lord, he has touched to this point first, my lord, that whether there was any Waqf or not, or what is the situation, that is also on record. If your lordship may see.
Has he declared such kind of entry as null and void?
At that instant, there was no entry. May I just assist, sir? There were no entry. The order is, my lord, the order is dated 10th of February 1996. The SDO's order.
Yes.
That is Annexure 2 of my petition. I
Yes,
have on it.
yes. And my learned friend will admit to this, that they got registered in collusion with the Waqf Board, I'll say, my lord. That ODC to say because no, that has been registered in 2000, and my lord, in the year 2002 and 3, they have filed again a miscase before Deputy Commissioner Devghar.
Appeal against that order of the SDO.
Sir, this is a
and that was set aside.
Is it a part of the record?
Yes, my lord.
Yes.
Whatever you are saying is
Yes,
a part
ma'am.
of this
Yes.
record?
Yes. Now, my lord, the Deputy Commissioner has relied to the 2002
the Waqf registration, my lord, and has set aside the order of the SDO. Where they, in the SDO court also, they tried to make this on forum that it is a Waqf property. Now after getting registered in the year 2000, they come in a case number 4/2002-3 after a lapse of 6 to 7 years. That is barred by section article 59 of the Limitation Act, my lord. They have used this registration document to get a order and set aside the order of the learned SDO. Now this order was in time limit, my lord, that was challenged before the Commissioner's court under the SPT Act. The Commissioner, learned Commissioner, has entertained the revisional jurisdiction, my lord, and has passed the order holding this that the petitioner's ancestors, my lord, they have looted the treasury there, my lord, in the property, and this Waqf thing has also been touched, my lord. And the Commissioner has come into point that it's not a Waqf property, rather it is a plot under the Ganges survey. It is a Ganges land, it's a government land, and the Waqf board is trying to grab the land of the government. That is the reason, my lord, why the recent amendment is and the bills have been introduced.
Yeah, we will
My
not
lord,
enter
I'm sorry to say
amendment and
that.
bills.
I'm sorry to say that.
85 का रजिस्ट्रेशन ऑर्डर
This
2002
is-
का दिखा रहे हैं रजिस्ट्रेशन 85 का है
Sir,
व्हाट
report-
स्टार्ट किया है
Sir, report
डॉक्यूमेंट है कंसोलर से 85 का रजिस्ट्रेशन
That has come in this.
85 का रजिस्ट्रेशन
आप
May I
इतना
just-
एजिटेटेड क्यों हो रहे हैं?
नहीं आई एम नॉट
हाँ तो आप वर्क बोर्ड है कि आप ट्रिब्यूनल है कि कौन है?
all sir blaming on court of these things or connivance what is connivance not
आपको लग रहा है कि हमको उनकी वो फालतू बात सुनाई दे रही है?
डिप्टी
या
कमिश्नर
कनाइवेंस का हम फाइंडिंग देंगे? आपको लग रहा है ऐसा पॉसिबल है? इतना दिन का एक्सपीरियंस नहीं हुआ इस कोर्ट का आपको? या कनाइवेंस का फाइंडिंग हम देंगे रीट कोर्ट में? वो सब सुनाई नहीं देता हमको। सिलेक्टिव हियरिंग करते हैं। कनाइवेंस का बात रीट जुरिस्डिक्शन में नहीं डिसाइड हो सकता। आप लोग इसका नोट्स बनाइए
Yes,
बढ़िया से,
अच्छा ठीक है, नोट
ठीक
बना
है।
के देते हैं, रिटर्न आर्गुमेंट बना के।
रिटन आर्गुमेंट बनाइए, हमको भी थोड़ा पढ़ने समझने दीजिए।
हाँ जी बिल्कुल, दो तरह से वक्फ हो सकता है, एक तो डॉक्यूमेंट डीड के जरिए वक्फ
नहीं
प्रॉपर्टी।
नहीं, हमको ये डिसाइड ही नहीं करना है वर्क राइटली हुआ कि रॉन्गली हुआ।
हाँ बिल्कुल
एक बार
सही।
जब क्रिएट का
हो
आ
गया
गया है तो
create,
प्राइम फेसी मेरा ये कहना
Exactly.
है कि अगर ट्रिब्यूनल है और एक बार आप बोल रहे हैं कि क्रिएट हुआ है तो ऑल दीज इश्यूज आर रिक्वायर्ड टू बी कंसिडर्ड। लेकिन प्राइवेट रेस्पोंडेंट का कहना ये है कि सिंस इट इज अ नॉन ट्रांसफरेबल प्रॉपर्टी,
दैट इशू दैट आई एग्री विद दैट, लेकिन उस टाइम जिस टाइम हम लोगों ने रिट फाइल किया था दैट
और
ट्राइब्यूनल वाज
ट्रिब्यूनल
नॉट
में कौन कौन
फंक्शनल।
पार्टी बनते हैं? ट्रिब्यूनल में कौन कौन पार्टी बनते हैं?
वही पार्टी बनेंगे, ये बनेंगे पार्टी उसमें।
नहीं, ट्रिब्यूनल में सरकार को भी पार्टी बनाना पड़ेगा।
सरकार तो यहाँ भी पार्टी होगी
तो यहाँ भी है स्टेट पार्टी।
कहाँ है सरकार? सरकार तो बैठी है, सरकार इज साइलेंट।
इसमें अभी जो वक्त अमेंडमेंट बिल जो आया है उसके अंदर में एक ही इशू
सुनिए,
पर बहुत ज्यादा
amendment bill का तो मतलब नहीं है।
इसलिए कि राइट ऑफ यूजर पे जो है उसी पर ज्यादा ईट है।
देखिए ना, तो यहाँ पे कोई लेक्चर चल रहा है,
नहीं बिल्कुल सही बात है,
ना ही हम लोग बिल को नजर में
उस पर
रखते
हम
हुए
लोग
कोई ऑर्डर कर सकते हैं।
बिल्कुल नहीं, हम लोग तो एक्ट
Right?
देख रहे हैं उसमें।
अभी एक्ट है, हम लोग एक्ट के अनुसार चलेंगे।
बिल्कुल बिल्कुल
ठीक है, आपका क्या स्टैंड है? काउंटर नहीं फाइल किए हैं? क्या लिखे हैं? ट्रिब्यूनल में जाना चाहिए कि नहीं जाना चाहिए? कहाँ से बोल रहे हैं? कहाँ से बोल रहे हैं? सुनिए, अपना कॉमन सेंस और कॉमन नॉलेज हटाइए और थोड़ा इंस्ट्रक्शन लेके आइए। कॉमन नॉलेज से इस तरह के मैटर्स नहीं डिसाइड होते, और इंस्ट्रक्शन लेना है तो राइटिंग में लेकर आइए कि आपका वो इंस्ट्रक्शन आप कोट करके ऑर्डर करें। ऐसे नहीं होता। ट्रिब्यूनल में आप भी पार्टी बनेंगे, इनको पार्टी बनाना पड़ेगा बिकॉज दे आर क्लेमिंग इट्स अ गवर्नमेंट लैंड।
गवर्नमेंट हाउस में पार्टी
आई डू नॉट नो, ऑब्वियसली वहाँ पे
वो नहीं है, वो तो बंद नहीं है।
इवन हाई कोर्ट फाइल होते हैं
प्राइवेट रिस्पोंडेंट जाएंगे वहां पे बिकॉज ही इज क्लेमिंग दैट लैंड, इट इज फॉर हिम टू फाइल दैट पिटीशन बिफोर द
कब
ट्राइब्यूनल।
सुने? ट्यूसडे हो जाएगा सब?
My Tuesday I'm out of station. I'm just request any day, my lord, after 7th.
मंडे एकदम ठीक है?
My lord, that week I have a personal problem. After 7th, my lord,
बताइए,
any day.
7 तारीख के बाद कौन सा दिन आएगा? बताइए अपना डेट सब आप लोग खुद ही चूज किया करें।
11th.
11
9th is
9th को ठीक है?
Monday.
आप लोग जरा
11th
सबमिशंस फाइल कर दीजिए.
Yes, madam.
ठीक है ना? और काइंडली रेफर टू द पेजेस which you are referring. Okay. या इसका कोई उर्दू का डॉक्यूमेंट तो नहीं है?
नहीं,
ट्रांसलेशन पढ़ना
नहीं,
पड़े हमको?
नहीं सर.
ऐसा कुछ नहीं है ना? और ये वर्क एक्ट ये तो हम ही लोग का है.
हाँ वही क्या.
Relevant provision I'll quote.
हाँ, you just quote whatever you want to. ये जजमेंट आपका है आपकी तरफ से. रिस्पोंडेंट नंबर कौन है?
Respondent 2.
देखिए प्राइमरी फेस से हमको लग रहा है कि आप जो भी इश्यूज बोल रहे हैं उसको रिकॉर्ड करके हम लोग ट्रिब्यूनल को भेजें. ऐसा हमको प्राइमरी फेस ही लग रहा है ना. लेट देम टेक अ कॉल वंस इट हैज बीन एंटर्ड. तो यहाँ से दूसरा कोर्ट से क्या ही नलिफाई होगा? बहुत मुश्किल है.
I'll show some 3 judgments.
और सरकार का जो कहना है कि नॉन ट्रांसफरेबल है, गवर्नमेंट लैंड है, एसपीटी का क्या इम्पैक्ट है, दे विल आल्सो बी अ पार्टी इन द प्रोसीडिंग्स. दे विल आल्सो प्लीड. जो होगा वो होगा. उसके बाद तो सीधे रीट में ही आइएगा जो भी पार्टी है.
उसके बाद आएंगे रीट में.
और अगर प्रोसीजर ही नहीं फॉलो हुआ है तो बात ही खत्म है. फिर क्या ही तो वही सोचा है.
इसमें प्रोसीड्योर जहाँ तक
ट्रिब्यूनल ऑपरेशनल है, नॉन ऑपरेशनल?
अभी ऑपरेशनल
अभी जस्ट हुआ ही.
Okay, the learned counsel for the parties are present. Counsel for the petitioner submits that the impugned order has been passed in connection with Waqf property. The property is governed by the provisions of the Waqf Act 1995, and the property in dispute is plot number
188. Just
1882.
1882.
Which was recorded as Eidgah in the record of rights.
Yes.
Eidgah and Mazar.
Eidgah and Mazar.
Eidgah and Mazar.
Eidgah and Mazar in the record of right. The learned counsel for the private respondent has submitted that the grave of the ancestors of the private respondent is on the property and it is their private property.
Yes, ma'am. It's a Ganser plot number 1882. That's a full name.
The plot number is Ganser plot number 1882. He has also submitted that the required procedure, he has submitted that the property cannot be said to be Waqf property by any stretch of imagination. The learned counsel has also submitted that without prejudice to this argument, the procedure, if any, in connection with recording this property as Waqf property under section 36 of the Waqf Act 1995 has not been followed, inasmuch as there is no mutawalli or the donor of the property. The learned counsel appearing on behalf of respondent number 2 has submitted that the tribunal constituted under the Waqf Act 1995 has the exclusive jurisdiction to decide the issue. He has submitted that once the property is registered as a Waqf property, as per the records of the respondent number 2, the tribunal would have the jurisdiction to decide as to whether the required procedure has been followed or not. He has also submitted that इनका प्राइवेट रेस्पोंडेंट का एक सबमिशन है. The learned counsel for the private respondent has also submitted that the property falls under the provisions is governed by the provisions of Santhal Pargana Tenancy Act, which is a special legislation for the area, and the tribunal will not have the jurisdiction to adjudicate in connection with such property.
Yes, ma'am.
He has also submitted that the property is the government land.
Yes, ma'am.
The learned counsel appearing on behalf of the state has also submitted that the impugned order does not call for any interference. इसके अलावा क्या ही बोलिएगा? He has also submitted that the property is a government land governed by Santhal Pargana Tenancy Act, and the action of respondent number 2 is not in accordance with law. यही अब वक्त बोर्ड है ना जिससे रजिस्टर किया है प्रॉपर्टी
इनका तो कोई काउंटर में बात तो नहीं हुई।
यही तो है इम्प्यून ऑर्डर
नहीं
नहीं इम्प्यून ऑर्डर में वो नहीं।
ठीक है लास्ट सेंटेंस मत
नहीं ऐसा नहीं It's not there.
Counsel for the parties are directed to prepare short synopsis.
I am relying on the judgment,
Arguments.
this order of the deputy commissioner, because the deputy commissioner.
आप अपना synopsis बनाइए
हाँ बना देंगे, हाँ बना के
detailed
देंगे।
synopsis of
हाँ
arguments.
बना देंगे। इसमें एक चीज सबमिशन था मेरा।
The matter is directed to be posted on 9th of December 2024 to be taken up at the 15th. Time मत मांगिएगा।
ठीक।
The written submissions be filed latest by 5th of December. ठीक है? इसको डिसाइड करेंगे। ये कौन रिलाई कर रहा है इस जजमेंट पर?
हम ही लोग कर रहे हैं रिलाई।
The petitioner and the respondent number 2
हाँ।
both have relied upon the judgment passed by Honorable Patna High Court in the case of Mudia Ellis, Hamida Khatun and others versus Bihar State Sunni Waqf Board, reported in 1996, Volume 1, BAJ 260. Passed in second appeal number 281 of 1989, decided on 22nd of November 1995. ये जजमेंट दे दीजिएगा उनको गोराई जी को, इसका पूरा हिस्ट्री जोग्राफी पता करना, आगे का कहाँ फॉलो हुआ है, क्या हुआ है, सब पता करके बताना।
इसमें एक्टिव को फॉलो हुआ, एक्चुअल में उसमें दो वक्त के लिए दो प्रोसीड्योर है। एक तो है रिटन डॉक्यूमेंट के थ्रू वक्त प्रॉपर्टी आप कर सकते हैं, लेकिन अगर यूजर के तौर पे अगर चला रहा है वो, तो देयर इज डजंट रिक्वायर एनी डॉक्यूमेंट फॉर दैट पर्पस। तो वो हम लोग उसी पर डिसाइड हुआ ये जजमेंट।
लेकिन इसमें तो डॉक्यूमेंट क्रिएट हुआ है ना?
नहीं तो कोई रजिस्टर्ड है वो, दैट मच इज देयर। और ईदगाह है, चला रहा है वो, नमाज पढ़ते हैं लोग उसके अंदर में, मजार भी है वो भी चला रहा है, ईदगाह भी चला रहा है, तो इसलिए इट कैन नॉट बी सेड दैट इट वाज प्राइवेट प्रॉपर्टी, इट कैन बी प्राइवेट।
कोर्ट को कुछ तो डिसाइड करने देंगे ना, यहाँ पे खाली एडजमेंट होता है। चलिए हम डिसाइड करेंगे।
अच्छा होता है बिहार स्टेट सुन्नी वक्फ बोर्ड जो है उसको पार्टी और
नहीं वो पार्टी बनाए हुए थे, लेकिन उन लोगों को ये नहीं है उसमें बहुत ज्यादा वो
मतलब वो रजिस्ट्रेशन 85 में हुआ है, झारखंड वक्फ बोर्ड क्रिएट हुआ।
आप डॉक्यूमेंट लाए होंगे ना?
रजिस्ट्रेशन तो
हम सर्टिफिकेट जो हमको मिला है वहां से वो हम एनेक्स किया हुआ है, लगाए हुए हैं रजिस्ट्रेशन नंबर के साथ। एंड इवन द कमिटी वाज कॉन्स्टिट्यूटेड, वो कमिटी का भी पूरा डिटेल दिया है 10 मेंबर्स कमिटी।
रिकॉर्ड के बाहर कोई बहस मत
नहीं रिकॉर्ड से बाहर नहीं है, वो सारा रिकॉर्ड में है।
यू मेक श्योर दैट नो आर्गुमेंट आई विल एक्सेप्ट व्हिच इज बियॉन्ड द रिकॉर्ड।
बियॉन्ड द रिकॉर्ड।
फ्रॉड का एलिगेशन लगाए हैं तभी बहस करिएगा, नहीं तो मत करिएगा।
बिल्कुल सही बात।
चलिए 12:30 बजे कुछ मैटर्स रखते हैं।
Passover case from Delhi list item 1 WPL 2947 of 2011 along with item 2.
Back together, Your Lordship, they are arising from the same reference case. This case is got list of dates to assist Your Lordship in this case.
Yes, please.
As notes, a checkered history notes, so may I not just take the Lordship
Yes.
to further note to understand what has to be understood in that
Yeah.
perspective. We have not appears to be not even the demand. Demand was made. Tisco Dues Division Recreation Club, not is a recreation club. Or similar recreation clubs not are functioning in other nodes company of the Tata Steel, like nodes in Telco and other places. They are called not clubs, basically they are clubs. And there was a demand raised not by the workmen, not 5 workmen. To the Lord's Club, President and Secretary was not the demand made against them. To the Secretary of the club. That notes at no point of time not Tata Steel or not anything, anybody, not or any company, even Indian Tubes company was not made a party in the conciliation proceeding. Demand was made against the Secretary of the club, who happened to be a notes in the employment of. Now it was not originally Indian Tubes company. It was later on taken over by
Then
Tata
what
Steel.
is the date of raising the demand?
It is 1990, lots, 1989.
1989. By that time, this tube division was merged with Tata Steel.
Tata Steel, yes. Indian Tube Company, and then it was later on merged with Tata Steel. So they claimed brought a demand against the Secretary of the Recreation Club. Conciliation failed, brought. Conciliation failed. A reference was made. Now, reference in this incident notices were given to Tata Steel and not to the Recreation Club Secretary. So, Lord Sir, we filed an application, but Tata Steel filed an application, came up Lord in the writ application, saying that reference is incompetent and not maintainable because at no point of time any demand was raised against the management. At no point of time it participated in the conciliation proceeding, and therefore the reference is incompetent, not maintainable. Then notes kindly take note, your lordship notes, the order of the High Court. Just note, take note annexure 1 first, is the demand, page 33. They addressed to the Secretary Recreation Club, Tisco Tubes Division, Jamshedpur. Then notes against which notes the reference was made at page 35. English version note is also there at page 37. Whether the workmen of Tisco Tubes Recreation Club, Baredi, Jamshedpur are entitled to get pay scale and other benefits admissible to the workmen of Tisco Welfare Department, Community Development Center, Hospital, Health Department and Electrical Department. If affirmative, then what pay they are entitled to and from what. So one is the parity of pay scale. We should be given parity with the regular employees of Welfare Department. Number 2, whether the workmen of Tisco Tubes Division Recreation Club, Baredi, Jamshedpur should be treated as the workmen of Tisco Tubes Division or not. So this was not even the demand. Point number 2 was not even the demand. First was the demand that our pay should be on parity with the workmen of the Welfare Department. But the reference was made not with regard to the whether they are employees, whether they are treated to be the workmen of Tisco Tubes Division or not. Against which notes? Initially, note when we came to the High Court, we know that notes the High Court note under Article 226 alone is competent not to decide about the maintainability of the reference, because the Labour Court note is a creature of the statute. The reference is bound by the terms of reference. It has to answer the reference. It cannot say that it is not reference, is not maintainable. And you see page 53 note, it's a typed copy I have not here enclosed. Writ application was filed by Tisco Limited.
Two 357.
Yes, notes. May I read the notes, the 2-page notes order? By notice, order of 1911-1991. By reason of this writ application, the petitioner has questioned a reference made by the state of Bihar in exercise of its power under section 10(1)(c) of the ID Act, earlier on the ground that no demand was raised by the workmen with the petitioner, as also on the ground that on the face of it the reference is not material. The question as to whether an industrial dispute exists by and between the parties or not may be decided at the first instance by respondent number 2 itself. In management of Express newspaper, Private Limited versus Madras, AIR 1963, the Supreme Court laid down the law in the following terms. High Court undoubtedly has jurisdiction to ask the industrial tribunal to stay its hands and to embark upon the preliminary inquiry itself. The jurisdiction of the High Court to accept this course cannot be and is indeed not disputed. But would it be proper for the High Court to adopt such a course unless the ends of justice seems to make it necessary to do so? Normally, the question of fact, though they may be jurisdictional facts, the decision of which depends upon the appreciation of evidence should be left to be tried by the special tribunals constituted for that purpose. If and after the special tribunals try the preliminary issue in respect of such jurisdictional facts, it would be open to the aggrieved party to take that matter before the High Court by writ petition and seek for an appropriate writ. Speaking generally, it would not be proper or appropriate that the initial jurisdiction of the special tribunal to deal with these jurisdictional facts should be circumvented and the decision of this preliminary issue brought before a High Court in its jurisdiction. We wish to point out that in making these observations, we do not propose to lay down any fixed or inflexible rule. Whether or not even the preliminary facts should be tried by a High Court in a writ petition must naturally depend upon the circumstances of such case and upon the nature of the preliminary issue raised between the parties. Having regard to the circumstances in the present dispute, we think the Court of Appeal was right in taking the view that the preliminary issue should more appropriately be dealt with by the tribunal. So and forth. Then note the last paragraph. In view of the fact that the petitioner may raise the contentions raised in this writ application before the respondent number 1, this is not the labor court, who may decide the jurisdictional points raised by the petitioner, we are not inclined to entertain this writ application at this stage. So the matter was relegated not to the labor court in view of the decision of 1963 that to decide the jurisdictional issue also. We thought earlier that it should be High Court alone, not should have decided it. As per the 1989 judgment and not the other judgments notes. National engineering case also, that under 226 note alone, the High Court is empowered. Nevertheless, notes, we file our lots WS on the following grounds notes. Only this much on the point of jurisdiction.
So you filed limited WS?
Limited. I will come to the written statement of the workman later on, but not first I am building up my case.
What is the finding on your this limited, a separate
yes,
order?
No, it's very peculiarly, and you see, it's very short note WS. Just then I will come directly to the order which was passed. Page note 49.
The page doesn't tally, so you can refer to the annexure.
By C notes. Annexure 4 note at page 49 if it is not the same. Actually, note there are a number of typed copies which are not.
It is at page 52 in my record. Oh. So there is a gap of 3 pages. Anyways, we'll figure it out. Yes, please.
Well, I will read from paragraph 2 onwards. The first is the reference notification which was enclosed. That as will appear from the next one, the reference is in 3 parts. The preamble will say that in industrial dispute exist between the petitioner and the workman represented by the workman themselves. Whether the said employees are entitled to pay scale and other benefit admissible to workmen of the welfare department and other departments of the petitioner. Whether the employees should be treated as a workman of the petitioner. And if the first part of the reference is non-S, the consideration of part B and C will be unnecessary. That at the outset the petitioner states, reference itself is incompetent and without jurisdiction. The basic facts in the support of these contentions are set out below. Said employees are employees of the club and not of the petitioner. There is no allegation anywhere that the petitioner employs and pays them. The admitted fact is that the club has employed them and they receive their wages from the club. There has never been any demand by the said employee on the petitioner. No conciliation with the petitioner has ever taken place. with whatever demands the state employee may have against the club, the petitioner is not concerned with them at all. It is thus manifest that whatever dispute is supposed to exist between the state employee and the employer, no dispute exists between them and the petitioner. The petitioner was nowhere in the picture and has been dragged into the picture in the reference itself. Then notes, we have said other things, notes, that we filed a writ application in the High Court, CWSC, and then note it was disposed of on the basis of 63 Supreme Court. Therefore, you have to decide these issues. Then note, the order was passed. That order note we have enclosed is.
So you said that it should be decided as a preliminary
issue. Because notes unrelated to evidence also.
Yes.
Who were the secretary and in charge of the club, and notes both oral statements were recorded by the Labour Court, and it gave notes of finding award in my favor. Annexure 8 notes. Annexure 9.
That was in your favor?
Yes, please.
Annexure 9. What is Annexure 8 then?
Annexure 8 note is the certain
Annexure 9 is the counter affidavit, as per my record.
Yes, yes.
And Annexure 8 is reference case number 22 of 2019, award.
My note is there are two writ applications notes. I am referring to note. I am taking note the 794 of 2012. Probably my note have taken up the 2011 matter.
Nobody referred that case number. That is why the pages are not.
Yes, yes. Therefore, I am sorry for that note. I could have pointed out note earlier.
Annexure 8.
No, it is Annexure 9 notes at page 116 of this brief.
116. This is dated 8th of October 99.
Correct, notes. 8th October 1999. The not just not the documents which Maros have seen in the earlier report are the same documents. Here also we have enclosed it. Numbers notes may, the page numbers may differ.
Just a moment. Let me just see since I was seeing from that report. I think it's the same document. Or just
Yes, the same document. The reference same, everything is same. Our WS is same. But I have referred to my WS, the order of the High Court, and the reference.
This is 8th October 99. Yes.
Yes.
Tell us. This is the preliminary issue or it's the final award?
It's the final award note which was given in my favor. Therefore,
Preliminary
everything
issue
ended
was
not.
not decided.
That issue was decided not, saying that it is not maintainable as against me.
Okay. Then why have you come then?
Therefore, I am such checkered history notes. Traveled up to the Supreme Court. So many things would have happened, but therefore I wanted not to apprise your Lordship not to all the facts.
Where is the finding?
Very
issue
convenient
number
for your
2?
Lordship not to then to not understand the conspectus of the dispute.
Yes.
The reference note here, the dispute has been referred to so and so, so and so. It refers to our note WS. It refers to our note's evidence.
Issues framed.
Issues
Para
framed.
7.
Yes.
So you are concerned primarily with
Finding
issue
notes.
number 3.
Finding starts from page 119 notes.
Yes. Internal page 4.
Yes.
Yes.
At the time of argument, it has been argued on behalf of Tisco
I
management.
think you are primarily concerned with issue number 3.
Yes.
Let us see straight away what is the finding and then we'll come to that.
No. Whether the reference is maintainable, the issue number 1 itself has been decided.
Oh, issue number
3
1.
issues were framed.
Okay.
Whether the reference is maintainable, whether the workmen of Tisco are entitled to pay a scale of the benefit similar to, and third is the whether to be treated. So he decides point number 1. Time of the argument has been argued on behalf of Tisco that what has been referred to this court for adjudication is not an industrial dispute in terms of 2K. In this connection, in the alternative, it has been also argued that for the argument's sake, it is presumed that industrial dispute exists. Same is not in between Tisco management and the 4 claimants of the case. Apart from this, it has also been argued on behalf of the Tisco management that the terms of reference is not in accordance with the second of demand attached with the notification. In this connection, further, it has been also argued on behalf of Tisco management that for the argument sake, it is presumed that industrial dispute exists, then it relates to wages in the circumstances dispute relating to wages has been described in the third schedule of the Act as per the provision of section 7A. The dispute described in third schedule may have to be referred to the industrial tribunal. At the same time, according to it, the work provisions of section 10, such type of dispute which has been mentioned in the third schedule of the Act can also be referred to the labor court if the dispute mentioned in third schedule is not likely to affect more than 100 workmen. In the present case, if an award is passed relating to the wage of 4 claimants, then in that circumstance it will certainly affect more than 100 workmen, and as such this one so. On the other hand, it has been argued on behalf of the 4 claimants of this case that what has been referred for adjudication to dispute is an industrial dispute. And the same dispute exists between DISCO management and 4 claimants of the case. The terms of the reference is in accordance with the statement of demand attached with the notification. Further, it has also been argued that it is facts that dispute relates to wages, but the award passed in this connection will not affect any more.
This is a clear finding
Finding what is
that the reference is bad and incompetent and is not maintainable, and there is no relationship.
yes, yes.
There is no industrial dispute as defined under section 2K of the Act between DISCO management and the claimant. Right? But it is not referring to any dispute between the claimant and the club.
Yes, club is not a party.
Club
Notice
is
was
not a
directly
party. They
given
have
to the
not been
management.
made separately party. They have not been noticed.
Demand was made to the club, but
They have
not
not been
management was
noticed.
made a party in the reference.
That's right. Okay. Then how are you agreed? The reference is not maintained.
Because not High Court notes interfered. I will come to that notes. May I come to the
Then what happened?
conclusions?
Conclusion I've seen.
May I note?
Internal page 12,
Yes, notes. Then what else?
para number 22.
I come to the conclusion that no industrial dispute as defined in 2K of the Act exists or appears between DISCO management and the 4 claimants at the time of making reference. As such, the reference is bad and incompetent and the same not maintainable. Answered note, and it has also answered other aspects note, whether notes there was not any conditions of employment and other things notes have been also referred to. We were not noticed at the time of note demand, we were not participating in the conciliation. That apart note, then note kindly see page 140.
Election.
Here the note, the game notes, 8, annexure 11 at page 140.
Writ petition.
Writ petition.
1802.
1802 of 2000, which was decided on 30th July 2008. Now, Lord, I will refer to note the findings, notes, to note my understanding notes. The High Court decided everything, and then it said, go back again to the Labour Court, which will decide. But when everything was decided, Lord, kindly see note, I will only refer to the relevant note paragraphs. Yeah, aforesaid paragraph 12 notes, page 143. The aforesaid finding of the learned presiding officer appears to be erroneous. That notes, tribunal already have not, Labour Court had held that there was no notice given to the management. He says, the court says, the erroneous on a bare reading of Annexure 1, which is addressed to the Secretary Recreation Club of Disco Division demanding proper wages before the management appears, that on the basis of aforesaid demand of conciliation proceeding was initiated by the Salary Authority in which the management participated, and when the demands were not fulfilled, a failure report. Management means not the recreation club management, not the disco management. And thus the learned presiding officer has committed an error. That is what notes. In any event, the representation has to be rotated to the secretary who also happened to be an official of disco. It was presumed that because he happened to be an official of disco, so therefore it was, the management was represented. Then can you see the next page notes? Page 144.
A finding was given that the recreation club is controlled, managed, and
Yes, yes.
But that is not the finding of the Labour Court.
It is not. But the Reed Court says that not they should be regularized because they have been working so long, and it is actually the worker of the Disco Limited. The fact remains that the recreation club is controlled, managed, and looked after by Respondent number 2, and thus The finding recorded at paragraph number 17 and 19 of the implement award is contrary to the facts and documents on record and thus unsustainable in the eyes of law. If not, if it is already held by the High Court, that the note is controlled and managed and nothing remains to be decided further. But then it not further says, kindly see note next page, 145 notes, paragraph 16. I will read note this paragraph notes.
Yes.
Be that as it may, the fact remains that the erstwhile Indian Tubes Company merged with Tisco Management, and after merger, the Indian Tubes Company became Tubes Division of Tisco. Activities of erstwhile companies once became division of the Tisco, and since then, the persons employed in Tubes Company became the employee of Tisco Limited. Respondent 2 has got various departments in the red state, so and so, so and so. In order to fulfill its obligation towards welfare of the employees and their family members, Respondent 2 runs and maintains hospital, dispensaries, schools, communities, and recreation club, and thus the employees in the recreation club are also the employees of Respondent 2, directly governed by the Department of Welfare. This is not a case of persons working in a canteen, run by a contractor instead of exhibits filed which include payment slip, medical entities, notices issued, allotment, other correspondence also, notices issued by the RPF Commissioner. They clearly reflect that they were under the direct employment and control of Respondent 2 and there was no intermediary. The recreation club, subsequently, recreation club is totally governed by Respondent 2, which also has a total disciplinary control over its workmen and even the wages are paid by it. Everything is finding note recorded without any notes discussion of the evidence, anything. Then it's note paragraph 17, kindly see.
These are based on evidence.
Evidence, I will refer to the evidence note. Evidence has not been discussed.
Anyways, then what happened? You
But
did
then-
not challenge this order.
I did challenge note.
Then?
I am therefore referring to what transpired. After the award has been given in my favor, these findings were recorded out of blue because not, if it was a maintainability to be decided, it was to be remitted to consider it on merits. But the report notes gave findings on merits also. Then it says in paragraph 17, the matter is remitted back to the Labour Court to decide the reference on merits on the basis of the records already available. Paragraph 17. Preferably within a period of 6 months from the date of receipt of a copy of this order. Now, if not, nothing remained to be decided on merits in view of the findings. We challenge it not in appeal. Now, appellate notes, court's order note is even notes. Kindly see at page 149. In appeal notes, it's a period court order note, kindly see paragraph 6. The arbitrary, the erstwhile Indian Tubes Company merged with the Tisco Management in the year 1986. The concerned respondents admittedly have been working since 83-85. We therefore fully agree with the reasonings given by the learned single judge in the paragraphs quoted herein above and findings recorded in the impugn judgment. It is high time the employees who have been working since 1983 should be treated as an employee under the appellant company. But we do not need no interference. Appellant may take all points available under the law. Now, nothing remained to be decided, not if it is decided by the division bench. Then not we went to the Supreme Court. Supreme Court not clarified it. Kindly see at page 151. We find no reason to interfere. First part of this order. However, it shall be open to the petitioner to raise all the contentions as may be available to it in accordance with law before the Labour Court. Labour Court, while deciding the matter, shall also not be influenced by any observations made by the learned single judge and division bench of the High Court in the impugned orders.
That nullifies.
So that nullifies. Therefore,
So
now
the impugned order has been passed on the basis of observations made by the High Court. Again.
Notes. Thereafter, note what happened. We filed an application that note allowing us to file an additional written statement because earlier we only had filed
on jurisdiction.
Jurisdiction issue and maintainability issue, and we did only 2 evidences. That order was not an order was passed rejecting that application. Against which note we came to the High Court, which is the other writ application. That we had a right note to give our evidence to show that we are not the employers. Our bank account is different, our provident fund account is different. And
So what was the material on the basis of which final
on the
award
same
has been
material
passed?
notes, on the same material now the Labour Court gives a different finding and notes upsets its own note order earlier given. Now, therefore, note, let us revert back to the WS of the workmen.
Yes, Mr. Sani. Just tell us where did they no. Let us just figure it out. No, just small point. The order by which the Labour Court refused to grant them an opportunity to file additional written statement. Although in the original written statement they said that they will be filing additional written statement, but it should be decided as a preliminary issue. We just have a look at that.
Your Lordship may kindly see the written
And in the
statement.
earlier writ petition also, it was made very clear that this has to be decided as a jurisdictional issue. As a preliminary issue, it has to be decided.
Nominal Your Lordship may kindly see the previous writ.
नहीं पहले written statement.
Yes,
आप आपको ये बताइए ये
Written
order first to justify this order, then only the final order can be justified.
First of all, my lord, Annexure 4, page 49 may kindly see. Annexure 4, page 49 is the written statement
Yes.
by Tata Iron and Steel Company Limited.
Yes.
It is not by Tube Company, what my learned friend submitted.
That's right.
No, it is, Your Lordship,
Because
just
by
see,
that time it was already merged.
March. So before the demand was raised, and if Your Lordship may kindly see, it was named as Tata Tube Company, the sale, the
When
part.
was the demand raised? That was my first question.
Yes, yes, that is Annexure 1.
That is
Annexure 1,
dated?
Your Lordship may kindly see.
Date.
Yes, that is in 1989. No, no.
By 86 it was merged.
Your Lordship, yes. Therefore, my lord,
Therefore,
that is
why,
1,
under what circumstances it
1/8/1989.
But
And Your Lordship,
when
just
was
see,
the merger done?
Your Lordship may kindly see clause A. My learned friend has the address portion has been read. But what is the demand? Annexure 1, page 33. We, the undersigned,
See.
such and such submit that we have been serving the welfare activities of employee under the welfare department of Messrs. Indian Tube Company
So
Limited.
therefore,
And
Mr. Sani,
now,
please pause for a moment. Right. Once the preliminary issue they raised, right?
that was a
They
final
will not.
decision.
They will not. No. You
This
see,
is final
preliminary
decision in
issue-
their favor.
Just
But my learned friend has referred.
preliminary issue was raised, that
Right.
was decided, and the entire case was decided on the point of preliminary issue that it is not
Your
maintainable.
Lordship, just see for a moment.
Yes.
My learned friend has completed so far pleading concern. First of all, Annexure 1, where we have mentioned that it is Tisco Company, it has been merged. Then Your Lordship may kindly see Annexure 3, our written statement. Then the notification. Now, after notification, Annexure 3, if Your Lordship may kindly permit me to refer to para 12, 15 and 18. Subject to Lordship. First of all, para 2. Para 2, we have categorically stated what is the reading. That Tubes division is one of the divisions of Messrs. Tisco Company. Jamshedpur hereinafter referred to the company, and the persons employed in the said division are the employees of company. Company means Tisco. It may be mentioned here that the erstwhile Indian Tube Company has been taken over by Tisco in 1986, and the activities of the erstwhile company has been made on the basis of the deviation of the divisions of the said company. Then Your Lordship may kindly come to paragraph 5, that in order to fulfill its obligation towards the welfare of the employees and their family members, the company means the Tisco runs and maintains hospital, dispensaries, schools to cater the educational needs, community center and recreation club to cater to the recreation needs of the employees and their family members, maintains township to cater the housing needs such and such employees, children for going to and coming to the school. Then Your Lordship may kindly see paragraph 6. That also.
Mr. Sani, you are not
so
getting my point. Please
Yes.
try and understand. Right?
Yes.
Their main grievance in the previous petition, the petition which was earlier filed, that is WPL 2947 of 2011.
Yes.
Their grievance is that they wanted to file additional written statement
Yes.
because they had filed the written statement only on the point of jurisdiction.
Okay.
Right?
Now,
That has been rejected.
That, Your Lordship, first of all, before why rejected, Your Lordship may kindly see me, Lord, this is on record. After leading evidence and everything, an award was, previous award, that is Annexure 9, page 40, page 106, Your Lordship may kindly see. That stage was over.
Mr. Sani, please appreciate that at the initial stage, the case was held to be not maintainable. And
That is
therefore issue number 2 and 3 No finding was recorded because there was no need to
Annex-
record any finding. First read का impugned order 1/3/2011.
For Annex 9, that is on final decision, award, final award, in their favor.
हाँ.
So
क्या है? What is the content of the final award? Read it.
116, your lordship may kindly see
You just see.
relevant part. Yes, relevant part.
Yes.
But I just
Para 22.
yes.
It
First
says
of all,
not
para,
maintainable.
para 7.
Para
7.
22 देखिए let's
Para
see.
7 are the issues.
That's right.
Issues are the
That's
para
right.
7.
You come to para 22 internal page 12.
Yes.
That the reference is not maintainable. Right?
Then your lordship may kindly see further also. Para 21, para 22. In view of the findings in respect of point number 1, I do not think just and proper to make any comment or to deal with the evidence other oral and documentary adduced on behalf of the parties in respect of point number 2 and 3. That is the reason I was referring what are those points. Your lordship just see paragraph 7.
अरे भाई finding ही नहीं ना record किया.
So that is in their favor. That was decided in their favor and that was
अब आपको
challenged.
बात नहीं समझ आता है तो ऑर्डर समझ आएगा, यही कर सकते हैं. आप मेरा बात नहीं समझना चाहते हैं या समझ नहीं पा रहे हैं. Initially the reference was decided that it is not maintainable.
Yes.
And therefore the other issues were not decided. There are 5 jurisdictional issues. Subsequently, when ultimately the matter was remanded and the Supreme Court observed that the case has to be decided on merits without being influenced by the order of the court, then under such circumstances, fresh order was to be passed on with regard to all the 3 issues, correct? So they filed a petition that they should be given an opportunity to file additional written statement, and that has been rejected.
By the first
Yes,
of the first.
and if that is rejected, then the final order is based on no evidence from the side of the
In fact,
petitioner.
one thing not left out. The decision
पढ़िए
has
आप
to be.
impugned order
हम
पढ़िए.
पढ़ देते हैं. हाई कोर्ट का ऑर्डर भी पढ़ देते हैं. अब सुप्रीम कोर्ट में मार्च हुआ वो भी पढ़ देते हैं.
हाई
Again,
कोर्ट का ऑर्डर
on my side.
हाई
Now,
कोर्ट
your lordship में
सुप्रीम
kind-
कोर्ट बोल दिया है
हम
कि
पढ़
हाई
देते-
कोर्ट का
पढ़
कोई
देते हैं.
ऑब्जर्वेशन से इन्फ्लुएंस नहीं होना
नहीं
है.
होगा.
तो इसीलिए
लेकिन
कुछ
क्या
पढ़ने
क्या
का कोई
डिसाइड
काम
करने
नहीं
के
है.
लिए वो भी बता रहे हैं. The lordship just see for that purpose I was referring page 109. There are 3 issues were failed. Your lordship is correct. In the previous award, which we have failed.
जो मेरे ही
they
बात आपको
succeeded.
दोबारा बोलना है तो काहे के लिए बोल रहे हैं?
ना मेरिट की बात
इशू नंबर 2 and 3 मेरिट में डिसाइड हुआ कि नहीं हुआ? In the
Issue
first
num-
round,
because the reason is issue number 1 was decided in their favor
fair enough.
and it was held that it was not maintainable and therefore the no necessity to discuss the other
Naturally.
2 issues.
Naturally.
That is the finding
That is the
in
finding.
their favor. Now we have challenged it.
No, you challenged it. Then it was so many
Yes.
orders were passed.
Yes, now-
Ultimately,
now
Supreme
let
Court
the-
said
whether-
that it has to be decided.
The mechanism of the what is to be decided in terms of the order passed by this honorable court and your margins honorable Supreme
No,
Court.
no, no. What is to be did? Nothing is to be observed. We will just read the order of the Supreme
Yes, yes.
Court.
The award was set aside by this honorable court, by the honorable single bench, page 140, after recording so many findings on the basis of the evidence on record. Because it was under, award was challenged, it was decided on merit, and that award was challenged by us, by the workmen, and the findings, my learned friend has read, my lord, already. I will just like to read only paragraph 6 and 8 of the earlier judgment in the honorable. I will just come
Of
to
the
Supreme
writ
Court. Writ court. Then
No,
it
we
was.
will not see that.
Sir, your
We
lordship,
will not see
your
that.
lordship, the findings were recorded.
Findings?
which were-
What findings?
I am coming to that. After then I will
Mr.
read.
Sani, if those findings are final and conclusive, what was the
No,
big
I am not
idea?
saying so. I am
Then
not saying so. In order to remove the suspicion which has been
there is
raised.
no suspicion.
That-
You might be having cloud in your mind, but
No,
I don't have
don't
any
have
cloud.
any cloud. I will just my mind is cloudful. I admit. But I will remove my cloud, my lord. For that purpose, I will refer. Now, your lordship may kindly see for a moment what was decided by this honorable single bench in order to remove the cloud which has been created in my mind. Now, your lordship may kindly see everything on the basis of the records of the case, exhibits, evidence, discussed everything. Now it was merged into division bench order. Your lordship just see for a moment. Division bench order, your lordship just see para 14 of that judgment, single bench judgment, para 14 has been quoted
14
in
and 16.
page 148.
That's right.
It has been, the discussion has been quoted. And
Yes.
lastly, my lord, your lordship may kindly see, my learned friend was appearing. The admittedly the what is has been recorded. Admittedly the asked while Indian company merged with the Tisco management in the year 1986. The concerned respondents admittedly have been working since 1983-85, so prior to merger. We therefore fully agree with the reasonings given by the learned single judge in the paragraphs quoted herein above and the findings recorded in the impugned judgment. It is high time the employees who have been working since 1983 should be treated as an employee under the appellant company. Whatever may be, this is the finding. Now, your Lordship, in the light of this finding, coupled with the finding of the learned single judge, your Lordship, just see the order passed by the Supreme Court. What has been done? Annex 13, page 151. We find no reason to interfere with the impugned order passed by the division bench affirming the order dated 30th July 2008 passed by the learned single judge remitting the matter to the labor court. So no interference for the purpose of remittance. Your Lordship is correct. I do not dispute this. Now, the special leave petition is dismissed. However, it shall be open to the petitioner to raise all the contention as may be available to it in accordance with law before the labor court. The labor court, while deciding the matter, shall also not be influenced by any observation made by the learned single judge and division bench of the High Court in the impugned order. Now, in the touchstone of this observation, the Lordship may kindly come to the order impugned in the secondary award.
No, by the award. First you.
There was no direction that it will be
no
raised as a
direction is
plenary
required.
objection.
No direction is required
Because this objection was raised by them.
In the earlier.
And it was decided. The objection which my learned friend is raising was the subject matter of the previous award, was the subject matter of the before the Honorable Single Judge, was the subject matter in the division bench, was the subject matter in the Honorable Supreme Court. What remains? Now, your Lordship may kindly see in the touchstone of those findings, if your Lordship may kindly test the legality, propriety and correctness of the award which is under challenge.
Final award की बात बाद में करेंगे ना, पहले वो interim जो order हुआ उसकी बात करेंगे.
Where is the petition, your Lordship? Just see.
Yes, you just see. You
yes,
just read this. 1/3/2011.
Annex 15.
You read.
Sorry, Annex
order dated 1/3/2011.
Annex 14. I'm just reading the language.
Pardon.
Page 152. That in view of the observation of the Honorable Supreme Court, the petitioner desires to raise all legal issues.
आप उसकी बात मत करिए.
हम उन्हीं का कर रहे हैं. उनका पिटीशन जिसका रिजेक्शन हुआ, जिसके खिलाफ वो फर्स्ट रेट में आया, उसी को हम पढ़ देते हैं. What is the contents of the petition? The Lordship just see for which the petitioner desires to file additional written statement in this case, and the additional written statement could not be signed by the competent authority, and hence some time may be granted to this petitioner. It is therefore humbly prayed, we kindly be allowed to the petitioner for filing additional. Where is the issue that I will raise a preliminary issue and that petition has been rejected? Now, your Lordship may kindly say Annex 15, Annex 14 is the after of the first round, second round litigation up to the Honorable Supreme Court. This is the petition filed. Now, what is the outcome? The Lordship may kindly say Annex 15 is the outcome.
Which petition has been rejected in your petition?
Page notes 1.
That is Annex 15, page 153.
First read से बताइए कहाँ?
153 हुजूर, second read में भी लगा है.
नहीं, आप ऐसे एक read से दूसरे में नहीं shift हो सकते हैं. आप हमको बताइए first read में वो document कहाँ है?
That is the order dated 1st March 2011.
1st March is the impugned order.
Yes.
Where is the petition which has been rejected by this order?
That is the Annex 14 जो हम पढ़ रहे हैं. That is the petition.
That is page 113 in the first page.
What I read just now. This is the petition. Where is the prayer for raising preliminary objection?
Preliminary objection नहीं.
Just
additional written statement.
They wanted to file an additional written statement.
Time petition.
Okay. What is the reason for rejection?
Yes.
Reason for relying upon the relying single judge's observation. It has been.
जरा 1/3/2011 को पढ़िए. दो पन्ना का ऑर्डर है, इसको पढ़िए.
petition हम ही पढ़ देते हैं उनको. जैसा पढ़ेंगे.
पढ़.
A petition has been filed on behalf of the management to allow the management to file additional written statement in the light of order dated 13/5/2010 passed by the Supreme Court, peruse the record. By award dated 8/10/1999, this court held the reference is bad in law and not maintained. The concerned workmen, namely Suresh Prasad Singh and others, moved the Honorable High Court in CWJC number such and such, which was allowed on 30th July 2008 by the learned single judge. Matter was remitted back to this court. The operative portion of the order dated such and such quoted. वो फिर नहीं पढ़ा तो सिंगल बेंच का ऑर्डर था. In the aforesaid background, this writ petition is allowed. The impugned award passed by the presiding officer Labour Court Jamshedpur is hereby set aside, and the matter is remitted back to the Labour Court to decide the reference on merits on the basis of the records already available. On merits, preferably within a period of 6 months, such and such. The management filed LPA against the order passed by the learned single judge. The said LPA number such and such was dismissed on such and such by division bench of the Honorable High Court. The management again moved the Honorable Supreme Court high SLP case number such and such, which was also dismissed. On 13/5/2010, after order dated 13/5/2010, reads as follows. Honorable Supreme Court का order उसे read quote कर. Considering the entire facts and order of the learned single judge, I find that this court has been directed to decide the reference on merit on the basis of the records already available within 6 months. Documents already available on the records, and that margin up to the Honorable Supreme Court. That is why he did not dare to pass any other order other than this order.
Supreme Court में क्या हो गया?
तो सुप्रीम कोर्ट तो बोल ही रहा है, तो कोर्ट भी किया है कि that is to be decided on merit on the
So according
evidence
to you,
on record.
as per this order,
Yes,
it
ma'am.
was to be decided on the basis of materials available and on record and nothing more.
Yes, that's
Right?
as per this order.
So what is
I am not adding anything.
what is the
No,
meaning
therefore-
of the observation of the Honorable Supreme Court that it has to be decided
for
in
that
accordance
purpose, your lordship has to see page 113. What was the prayer? Which was the subject matter of this impugned order?
Also
Whether there was a prayer that I shall raise a preliminary objection.
Not preliminary objection. Petitioners
I
have
am
raised
not-
all
I am
the
not saying
conditions.
more.
1:30 बज गया, second half में लिखाएंगे. हम सुन लिया, आपका सारा कहानी लिखाएंगे.
Now, your lordship may kindly see the under this above mentioned circumstances, the prayer of the management to file additional petitions is hereby rejected, and that is under challenge before the honorable court, my lord, in the first writ petition, and there was no stay. Therefore, my lord, the matter proceeded, and ultimately the final award was passed, and that final award is subject matter of the second writ petition, which I am here, in which one of the workmen out of the 5 have already been, the matter has been settled, and he has been paid ₹7,50,000.
That settlement
And
was
that,
not bearing.
that is the reason his name has been deleted.
That's right.
So implemented that award for any reason or other.
He was discharged not from service.
But
No, whatever
So
it is.
that has been settled. I am not saying that that settlement will be a binding upon us also. But the matter relates to 1983, dragged to 2024. For 41 years.
Judgment of our Lord High Court with regard to Elko Recreation Club has come now, Lords, exactly on the same terms of reference and same facts.
What happened?
Lord, it has been said that they are not the employees of the management of Elko. I am not kindly saying, Lord, I am giving a copy, Lord.
Yes. For that purpose, I have to address this honorable court
No, कुछ का
with
जरूरत
regard to
नहीं,
the
please.
final award.
किसी का कोई जरूरत
Final award, if it is wrong, then I have to support it. If they confine to the first read, and what fell from your lordship.
If the first street goes, the final award goes. Right? If the first street sustains, then only the question of
Therefore,
entering
the
into the final
legality,
award.
if they attack, the second writ petition is concerned, then I have to address this on court.
You have to, of course, contest the case on merits. We are allowed to raise all questions available to us.
And that has been raised in this second writ.
कहाँ allow किया हमको? WS ने written से
तो
कुछ
सब चीज डिसाइड किया है, जो preliminary objection है, that has also been decided in the award. And before your lordship examines the first writ impugned order, it has to be read with the final award, and what has been decided and what has been raised. Whether it is left out, for which purpose will not this will serve the purpose.
In the final award,
Yes, ma'am.
how many witnesses were examined?
Earlier to the final preliminary order.
I want to know
In
how
the
many
final order in
witnesses
the
were
previous
examined?
date, no further evidence.
That's right. How many witnesses were
Five
examined from your
witnesses.
side?
5 witnesses.
From your side.
Yes, yes.
And from the
The
side of
2
management?
witnesses.
From the side of
Yes,
management?
and the exhibits were marked from both sides. Everything has been done. You know, just see the award. That is 100 Annexus 17. Paragraph 6. Page number 164. Management examined 2 witnesses. They filed their documents which were marked as Exhibit M1, M2, MW1, MW2, MW3, MW4. Four documents. Then para 7 relate to the workman. The workman examined 4 witnesses. And they also
We'll continue in the second half.
Procedural